Mic check. Good morning, everybody, and welcome back to docket number 241004. We're going to go back on the record now, and we will pick up where we left off yesterday with OCC's cross. Thank you very much.
So just excuse me, Ms. White, just before we start, Commissioner Arconti, we do have read-in A, I believe, if we'd like to take care of that read-in before we kick off the cross. Ms. Pillell, no, go ahead.
Hang on one second. Let me get a pen out. Make a note for the record over here. Okay.
Ms. Pillell, since yesterday's hearing, were you able to locate the information requested in read-in A?
Yes, the costs associated with CAE 40 are related to the LIDR, and the actual the capital costs associated were incurred with the two-tier implementation. So those are the costs that are captured there.
Thank you. And I think that is it for read-in A, and I will turn it over to Ms. White.
Ms. White, could the microphone, I think. Yeah, thanks.
So first off, I need to revisit a couple of things that we were talking about yesterday before I get into the rest of my cross. We were discussing EOE 229 and the fact that a newly eligible customer couldn't enroll on MPP until they receive SEEP. As either a read-in or a late file, read-in is fine. Could you provide me the decision or the motion ruling or the whatever from the authority stating that?
Can you clarify that?
So yesterday we had a discussion where we were talking about EOE 229 and EOE 229. We had a call. It was from April of 2024, and we were talking about the two-phase MPP at the time, and we had a discussion in which we were talking about how a customer. You said that a customer couldn't enroll on MPP until they received SEEP.
Correct.
Okay. Could you provide me, as I said, a read-in, I assume was probably the best method. The whatever from the authority, motion ruling decision, I'm not sure what, but that says, that approves that right there.
Okay, to the extent that we can take that as a read-in, and we can get back to you if that's not possible and maybe convert it to a late file if necessary.
Certainly. So I don't know what read-in we're up to. I'm sorry.
Yeah. So we'll mark this read-in
C.
I was going to say B, C for today. Could you just repeat that again, Ms. White, for my notes?
Yes, it will be a read-in regarding the authority ruling stating that a customer could not enroll on MPP until they received SEEP in the former not the new MPP, the former version of MPP. And do that. And actually, I'm going to clarify this and read in B ever so slightly, if I could. To the extent that the authority's ruling in any way is sort of a blanket approval of a filing, could you point me to where in your filing you stated specifically the MPP SEEP interaction that I was just discussing and the BFP interaction from read in B that we were discussing yesterday? Does that all make sense to everyone?
Maybe to others, not to me, just the latter part with part B. You're adding on to the question with B.
I was for read in B, as I said, to the extent the authority's ruling that you're going to point us to is a blanket ruling that just simply says something like, we approve your filing, or, could you point to where in your filing at that point it said what we're talking about?
In B regarding the
Yes,
re-enrollment of BFP.
Yes, ma'am. And
Okay.
same for C.
Okay. Thank you.
I'm good with the construction.
Yep, thank you.
Let me know when you're ready.
Yep, all set.
So returning again to the BFP question that we were talking about yesterday, which was EOE 222, but I don't know if you necessarily need the question. How many times was a customer allowed to fail BFP and re-enroll without making any payment?
So a customer could re-enroll in BFP. There wasn't a cap on how many times that they could re-enroll. They would be removed after 2 missed payments. So they could potentially miss 2 payments, re-enroll, miss 2 payments. I would have to do the math on that, but it would be, at probably 3 to 4 times per year while enrollment was open. Have to do some quick math on that.
I understand. But there wasn't a limit on it, I guess is my question.
I believe it would be 4 times, right? So the 2 missed payments, 2 months, they would be enrolled for a month, missed 2 payments. So it would be 4 times that they would be able to re-enroll in BFP in a calendar year.
Okay, and just to clarify, we're talking about each time they re-enrolled, or the question that we were talking about yesterday was that when they re-enrolled, they could essentially, they didn't have to make up missed payments to re-enroll, that they would essentially roll their missed payments into the new amount that they owed at that point?
There were 2 options. So that they could be reinstated by making up missed payments or re-enrolled without making payments.
Okay, and either option continues in the, you said 4 times a year, but either, they could do either one.
Correct.
Okay, now returning to our discussion toward the end of the day about your MPP programming and that it's currently not removing customers who have failed MPP. Are any costs associated with your MPP system upgrades included in this rate case?
I don't believe so, but it's subject to check.
Could that be a read-in or something
Yes.
to clarify?
Yes.
Was that read-in D? Which would be clarification as to whether or not any new MPP redesign costs are included herein. Okay. Okay, so we'll turn to a couple of new questions now. I'm turning to OCC 156. And I was just trying to understand the complaint escalation process.
I have OCC 156, correct?
That's what I think, but maybe I've,
Okay, and that has it related to customer service positions.
uh,
Okay.
yes, and it's about yes, that was, that interrogatory asked the roles of different people and that were involved in the complaint escalation process.
Thank you. Just want to clarify we had the right.
Yes, that was the correct interrogatory. So, if I understand it correctly, if a customer calls you directly, the call goes to a CSR, and then if there's a complaint about that, that complaint is escalated to a customer care supervisor, and then up the chain to customer care manager, review officer, director.
So when you say complaint, can you clarify how you would classify a complaint?
what would, okay, let me take a step back then. If a customer calls you, what would cause the call to go from the CSR to the next level, to the customer care manager?
There's a couple of different reasons. One, it could be that a customer is unhappy with a situation and requests to speak to a supervisor or a next level employee. It could be that the CSR handling the call, the skill set required to talk through the issue with the customer maybe hasn't been developed yet. So they need to reach out to a resource that's better versed in handling that sort of a situation. Or it could be a request from by the customer to speak with a supervisor or a lead representative.
Okay. So for those situations, the chain that I described is correct? CSR, customer care supervisor, customer care manager, review officer, director.
So it'd be customer service representative. In the internal center, it would be a working lead, a working leader position, then to a supervisor, potentially to the lead supervisor, then manager and review officer.
Okay. And then you were describing yesterday, I believe, with authority staff. I'm gonna paraphrase this for my own purposes, a separate escalation process for calls that aren't coming directly to you from the customer. So you gave examples like calls coming from EOE or from another state agency, or I think you said Better Business Bureau or something like that. So those complaints go to the manager of customer escalations, who leads company review officers.
Yeah, just to clarify, it goes to the review officer team, those complaints, of which the manager is one of them, and then there's 2 review officers that report to the manager.
And typically a review officer on that team would triage the matter and if needed, would engage the manager of escalations as necessary.
Okay, is the manager of customer escalations the highest spot in that chain, or does it go beyond that?
Of the review officer team, yes.
Okay, so for the calls that are coming in from EOE or something like that, the manager, you're saying is the top level?
Correct.
I mean, the manager can consult with, me, Nick, others, as needed, in order to resolve an issue.
And what I've been describing here has kind of been what I'm picturing as 2 separate chains. We have the chain coming in through the specific customer call, and then the chain coming in from calls or from complaints from a different source. And both of those have company review officers in both of the chain of the escalation. Are these the same people, or are they siloed?
The same people.
Okay. So in OCC 92, you gave us some tallies of complaints received from EOE. Those complaints would have gone through the second process we're talking about, the one that culminates in the manager of customer escalations?
Correct.
Okay. So in OCC 92, we see the number of complaints that they receive from EOE each year. It is the total number of complaints that they received, like from something other than EOE, someplace else in the record, do you know?
Let me check.
I will confess that I didn't find it, but that's why I was checking.
Yeah, we can take a look and,
So then could we make, I don't think it's there, so in case your little late file could be either
yeah.
you
sure.
file it or you.
I mean, we have those records. I'm just not sure if it was one of the interrogatory requests.
Okay, then could we have a late file exhibit of that, please?
I believe we are up to late file exhibit 5. And Attorney White, if you could summarize for me, please.
Yeah, the total number of complaints received, I'm gonna call it external sources, like not directly from the customer. We discussed the 2 different chains. So chain that the EOE and other agencies and would be in. Does that?
Did you want the same time frame as the OCC 92?
Yes, ma'am.
Okay.
And will that, would the LFE, will it show the number of, where it made it in the escalation chain? Is it possible to show that in the LF? Does that make sense? Because I mean, we know there are a couple of different.
So
steps.
just to clarify that, those records that we would provide include the executive office, the Better Business Bureau, things like those come directly to the review officer. So there's not that hard
Okay.
hierarchy.
Okay.
Yeah, so it does break it down by source.
Thank you. Let me know when you're. Okay, turning to CAE 11. In that interrogatory response, you describe what each of these positions has established, things that they've set up. But now that all of the different things that these positions have established are in action, what do these positions do on an ongoing basis?
I can speak for the knowledge base analyst. It requires a full-time effort to maintain the system, keep the system updated, input new users, take out users that are no longer in the system. But with the information flow so constant in the call center, they have to ensure that that information gets to the knowledge base system quickly and accurately. There's also I think 1,000 pages of information in there that has ownership through various departments like credit and collections and billing. And it's their job to ensure that that information gets updated. Training uses some of that information, so we need that material updated. So they're proactively working on a day-to-day basis to make sure that the system is up and ready and has all the correct info. The speech analytics person is still doing fine-tuning topics and phrases as we've discussed and is making some progress. What we have to do today is so if we put a topic or a phrase in there and we run it over X number of calls, then we need to really go back and listen to those calls and line it up to ensure that our speech analytics tool is working the way we want. And that's what that person is doing right now. We have a lot of phrases and topics in there that we're going back and trying to verify and validate.
And futuristically for the speech analytics role, they would be, migrating either topics or research that we've done to the new system that the company will be moving to. So they'll be going through some of the same processes and they'll be slated with running queries using the new platform's speech analytics tool.
And just to add on what was already commented on, we did just recently speak with the speech analytics analyst regarding some analysis that was done. It had to do with confirming that the CSRs are providing information about programs, identifying some repeat callers and what the topics were, potentially reviewing for any audio issues that might be detected through phrases being used, customer sentiment with words used. So the analyst is constantly using the tool to try to identify some unique trends as we understand that we're transitioning hopefully to the more robust tool with our new platform.
And I can round that off in regards to the senior digital product owner and lead digital business analyst. So their job really comes in two folds. One is to deliver new capability as we've outlined in the interrogatory. But the second thing is to make sure we have a robust and resilient platform for our customers. You know, if you think about contextually, again, we've now got 83.6% of our customer interactions happen through digital tools on an annual basis. So we need specialists that are skilled in these technologies and practices to make sure that our customers have an excellent standard of service. So, for example, you know, they would take feedback from our voice of the customer framework in regards to customers using the new Apple Pay process or conversations that would happen through our virtual assistant online. And look for opportunities to further enhance and optimize those tools to further improve, as well as if we have any you know, opportunities within our contact centers to further deflect call volume and to put these contacts onto our self-service tools. They would work with our research capabilities across our kind of customer service rep channels as well.
I'll take over for Attorney White. Good morning to the commission and to the panel. Claire Coleman, Consumer Counsel. I had a few general questions about the current state of collections practices under the, after reviewing the testimony, I had a few questions, particularly in light of the authority's most recent decision in the energy affordability docket, the 240501. That I don't think were addressed. Feel free to refer me to any written discovery if that's not the case. In the final decision in 240501, which was issued in November of 2024, the authority directed the company to resume legal collections for all residential customers. Can the company describe what steps it has taken, if any, to resume those collection efforts?
So for residential customers, we have looked at the receivership option for a community that we had a customer with SCG and NUI. As far as there were tenants in residences that we didn't have any recourse to be able to disconnect their service because they would not be able to be individually metered. So we opted to do receivership there, and I believe we had shared that with the OCC and EOE at the time. We are looking to do some additional steps like that. We are planning to go out to RFP for a legal firm to select in order to proceed with additional legal actions for residential customers as well as commercial customers.
Okay, thank you. So it sounds like you've not yet resumed work with a legal collections firm, but the company intends to?
That's correct.
And that would be for active customers or active and inactive accounts?
Yeah, just to be clear, we have continued our practice of inactive customers. So finalized customers, we refer to third-party collection agencies. We have not stopped that practice. In fact, we went out to RFP. We selected the vendors, and we've just engaged with those vendors. So that's an ongoing practice that we refer those accounts. I believe it's approximately 44 days after the account is finalized. So that has not ended. We do that with active as well as commercial customers that have ended their service with us. So that's continued.
Thank you. That's a helpful clarification. So for those finalized accounts or inactive accounts that are going to third-party collection, would that include both hardship and non-hardship customer?
Yes.
Finalized accounts? Okay. And then I guess you haven't restarted, but just to make sure we have the different tunnels, for the legal collections firms, they're focused on active customers, and that would be both financial and non-financial hardship
Yes.
customers? Okay, thanks. And it may be premature if you're still in the RFP stage, but has UI made a final determination about the outstanding balance threshold it will ultimately use to determine when to refer an account to legal collections?
We have not.
And what about customers protected due to a serious illness or life-threatening condition under the medical hardship category? Does the company have any procedures in place currently to attempt to collect those unpaid bills?
Yeah, those are very difficult, as you know, because they do have full year-round protection if they have life-threatening medical conditions. So we try to continue our communication with them. We do periodic mailings to those customers to encourage them to enroll in programs. So that's mainly our mechanism to do that. We do on occasion make outbound calls as well when we can. Those don't tend to reap many benefits because the customers have, but we have made some progress. I believe some of our data shows that we've reduced the number of customers without any type of payment arrangement. In other words, we've increased the number of customers that have payment arrangements that have medical protection. Not as much as we would like, but we have made some progress.
And are the medical protection arrearages, it sounds like you have an internal company procedure to address that. Would those also be subject to the RFP for the legal collections firm, or are they handled
I would
differently?
have to review the approval that we received. I'm not sure that we can pursue hardship the medical customers, but that's subject to check.
Okay, thank you. Could we actually ask for a read-in on that once you check?
That's read in D, I'm sorry, E. And if I could just throw in a clarification there while we're on it, Ms. Palella, are you referring to the approval like from Pura or from your?
In the energy affordability docket, there was commentary on being able to restart legal collections activities. So it's to reacquaint myself with that language.
Okay, thank you. So we'll make read in E.
Yeah, and the question was whether medical hardship customers would be referred to outside legal collections firms.
Thank you.
So similarly, in the affordability docket decision, the authority directed the company to, that it may resume wage garnishments on or after January 1st, 2025 for all residential customers with incomes at or above 75% SMI. So I have a similar question, whether the company has initiated this process.
We have not, and there are various stipulations in there as well, various steps that we need to go through. So we have been pretty occupied with some of the other regulatory activity. So we haven't dug into that yet, but it is one of the aspects that we will look at.
Yeah, I believe that the decision, you may have been referring to the requirement to develop communications materials if and when you restart wage garnishments.
Notification requirements as well.
Correct, right.
Yeah.
So has the company made a determination about moving forward with wage garnishment? It sounded like you said, you haven't had time to put a plan together, but I'm just curious, has the company determined it will be, once it has the time, it will be presenting to the authority the notice and communication?
Yeah, I think
requirements?
our interest is to definitely take advantage of any of the tools that we have available to us to try to reduce these, arrears balances, and that would be one of them.
Okay, thank you. Does the company have a timeline in place where it anticipates?
I don't at this time. I think we're going to get together with our legal team and look at the RFP process and see how quickly we can move that forward.
Thank you. And then with respect to customer data protection on arrearage balances, we're aware from communications, we've had a meeting, Ms. Palella, we had with some of your colleagues in mine about the CNG SCG customer data that was released inadvertently by the company in response to a scammer. And I'm just wondering if any UI customers were impacted by that?
They were not.
And am I correct that it's the same customer service management team for both accounts for CNG, SCG, and UI?
No, that is not entirely accurate. It depends on the role of the
Okay.
person.
So since this is UI's rate case, we'll focus on UI. What protocols are in place at UI to prevent customer service agents and collections management from releasing customer information regarding bill arrearages or other personal account information
Releasing it to whom?
to a scammer or to actually, given that employee may not be aware that it's a scammer, just internal procedures and processes that would address sharing information internally. I believe in the instance of the recent incident, it was an email where the employee believed they were sharing information with the president, Frank Reynolds, correct?
Correct.
So in that scenario, curious about training and procedures that UI might have in place to help prevent such incidents from happening at UI.
Yeah, we have a very robust expectation around information that there's no reason why any employee, and that would be management employee, would have access to information that would send it to anyone outside the company. So would not be a practice that would occur.
Yeah,
We also have, sorry, just that unilaterally a cyber protection framework. So we have a cyber security team within the group, and they have a very rigorous training program in regards to email phishing. So, for example, we, as an employee myself, have to go through that training, but then we get tested upon that training, i.e., there'll be fake phishing emails sent to employees of all levels, and the performance of the response against do we click this is an email phishing, or do we respond to that email, tracked and kind of managed through from a training perspective as well. So there's a really rigorous due diligence set of protocols put in place.
Yeah, throughout the year, we equipped all of our customer service representatives with information regarding watching out for phishing. We equip our customers with bill inserts and periodic communications. And as Mr. Patterson shared, it's consistent phishing attempts by our security team to make sure that we're aware that these are the types of incidents. And as we become more aware of the different types of angles that a phishing might occur, then they do new tests and making sure everybody's up to speed on all of those aspects to watch out for.
And beyond that, within the email system utilized by the company, that phishing button or add-in is available for any email that comes into the company. And employees are highly encouraged multiple times throughout the year that if they do see an email that they suspect might be phishing, even if they're to some degree certain that it might be a legitimate email, that they can utilize that phishing button to get confirmation whether or not it is phishing or not. And it'll come back from corporate security saying that this is okay, you're okay to proceed with opening this email or responding this email, or this is in fact phishing and we're going to take action on it.
And that response comes in a matter of minutes. It's very, very quick. And it's very quick to indicate if it is a phishing attempt. They will confirm that very quickly.
Thank you. And just to focus on the handling of customer information internally a bit more. Yesterday, you discussed with Attorney White that hardship documents stay with the customer's account for life. So for example, if you got a tax document or a W-2 or a pay stub, that would stay within that customer's file for life. What is your process or protocol to ensure these materials are protected and aren't released?
Well, so within the security setup, there's need to access, and so it's based upon security roles. Only representatives of the company that are authorized to view customer information have the ability to access that information. So CSRs, management members of the customer service organization, that's a security access based role. And unless you are granted access based upon the need of your position, you would not be able to access that information.
Thank you. That's really helpful. And are there any written procedures that sort of memorialize those protections that you just summarized?
Within the customer service organization, there isn't a written procedure. However, in detail, the training that each employee goes through each month regarding PII and SPII does talk at length about need to access and what employees have access to certain information, and the fact that it is predicated on roles-based security rights. So it's more or less a training document rather than a procedure, and that's a requirement each year for all employees.
Great. Could I request a late file exhibit on that training document that was just described?
To the extent that we could produce that, it's one of those, self-paced training modules with the videos and pop-ups and click on this, and I don't know if we're able to produce that, or can we?
We'll do our
I-
best.
Perhaps,
We'll do our best to
Electronic
get that into the record in a format that makes sense.
great. You could share screenshots or, if you can't share the live version.
Okay, thank you. That's late file exhibit 6.
Great. And then I recognize you have a separate cybersecurity team, but in terms of the customer service interface with customers in the event there's a data breach or a sharing of customer information, are there procedures in place that the customer service team is involved in direct outreach or to inform customers, for example, that their information was shared?
I mean, we typically would work together with the corporate security team. It would really depend on the incident, the situation, the circumstances, and we would, work together with a plan. So
Okay.
it would be
Yes.
led by our corporate security team.
On the UI side, has any such incident happened in recent years where you had to put together such a plan?
I'm not aware of one.
All right. I think those are all my questions. Thank you very much to the panel, and I'm going to turn it over to Attorney Wheel.
Good morning.
Oh.
You here?
The mic.
Tom Wheel for Office of Consumer Counsel. I'm going to start with a question about OCC 828.
I think we have it up now.
Okay, so I understand this response to say that there are 339 accounts that are non-financial hardship, non-medical hardship, residential, or commercial and industrial with a balance greater than $10,000 that haven't been disconnected. Is that accurate?
It was accurate at that time, yes.
Okay. And there's a the narrative notes that the company wasn't able to explain on a account by account basis why they hadn't been disconnected, but it gave some like potential reasons why that might be. Is that accurate?
Yes.
Okay. So I tallied there was an attachment with a spreadsheet showing individual accounts and the balances. It looked like there were 219 residential accounts there. And 82 of those had a balance greater than 20,000. Does that sound correct?
Subject to check.
Okay. And the narrative response offered one of the reasons why these accounts might not have been disconnected when the response was provided was that there might not be an AMI meter in the home. So so my understanding was that there couldn't be a remote disconnect. Was that
Correct.
okay? So does the company have any process in place to disconnect accounts that don't have an AMI meter?
We do.
What is that process?
Yeah, it gets identified and then dispatched to the field in order to disconnect.
Okay, thank you. Can you describe your process of determining like the prioritization of disconnections?
Basically, for the AMI accounts, they're identified, and by looking at the dollar amounts due. At times, it depends on, it's whatever comes up eligible in the AMI system at that time, at that day. So depending on the volume, we may be able to do them all. We might only do a portion of them, depending on the volume and the contact center impact. So that's how they're identified.
Okay, so when disconnection, when an account's eligible for disconnection, it goes onto a report, it sounds like, and
It's an automated process, yes.
Okay.
And then the ones that are manual, those are reviewed by someone and then given to the field operation in order to dispatch.
okay. And that's like rolling a truck to the actual location.
Exactly.
And are those prioritized based on balance due?
They typically are, or it could be the area that they're in that particular day. And then whether or not, depending if they can get access to the meter, or if additional steps need to be taken in order to disconnect.
Okay. And a second ago, you were talking about the AMI disconnect process. And I understand that from your response that part of the consideration for how many accounts to disconnect at a time is the potential call center impact. So is that like, obviously when someone's disconnected, they're likely going to call the call center?
Yeah, there's almost a 1-for-1 correlation with a disconnect and a call. And on days where we have, 5,000 potential disconnects, if you were to perform all 5,000 disconnects, you'd be, creating 5,000 additional calls in addition to your normally, your typical volume related to other types of customer inquiries. So you would inundate the staff that exists, creating excessive wait times, which would likely persist for days because you're not staffed appropriately to handle that. And likewise, it wouldn't necessarily be prudent to staff for that level because you're not going to see that volume for the majority of the year. So you'd be staffing for a peak period of time. So we staff to our average volumes, and then when it comes to managing disconnect volume, we will look at what our staffing levels look like for the day, make a determination of how much we believe we can perform in that day. And we've done in instances, we've gone back and said we have the capacity to do several more disconnects. So let's start them back up or add to the number that's already been done. So we manage that actively each day.
Okay, thanks. So I was about to ask whether there's sort of like a limit per day, but it sounds like from your response that it's like a judgment in the moment depending on staffing levels, and that can be adjusted in real time, maybe?
Well, we take a number of things in consideration. You know, we know based upon, you know, the time of the month, what the volume is generally going to be, right? Because our bills go out in cycles, right? And there are certain geographic locations generally assigned by cycle. And then we have periods of open billing. So we know week over week and day by day what the volume will likely be. So we'll take a look at the volume of disconnects, what we think we can perform, and we'll adjust as necessary. We do have, you know, kind of a target amount that we think we're appropriately staffed to do. And then again, depending on staffing on that particular day, we'll modify that up or down.
Okay. And out of curiosity, you mentioned, I think that like there are different times of year. Is it like post seasonal moratorium would be the highest time for staff, like for incremental staffing?
That's the highest eligibility for disconnect, yes, is coming off of the moratorium.
Yeah, we're also looking at the number of shut off notices that are being mailed, because we know, generally when the customer gets those notices, they're going to call. So it's a combination of all the activities we understand that's going to impact the contact centers at the time.
And then from a staffing perspective, when we do our capacity planning models, we look to make sure that we have our max approved staffing levels during that time of the year.
Thanks. So I'm going back to like the narrative response to 828 on page 2. I referenced that there are 4 kind of bullet point example reasons why a residential account might not be able to be disconnected. It looks like 2 of them, the first 2 pertain to AMI, which we just talked about. The third one has to do with mixed wiring, and I was curious about that response. Does the company know like which residential accounts have a mixed wiring issue?
I mean, that's once they're identified, we may know. So a customer would contact us and let us know they feel they might have that situation where they might be paying for hallway lighting or something like that. And they would contact us, and then we would investigate the situation, and then we would notify the landlord that they need to rectify the situation or take responsibility for the bill. It's not a large volume. I think that was just one of the reasons that they were aware of that might occur.
Okay. Does the company have like is there a policy? So I'll back up. In a mixed wiring scenario, I imagine there's a dispute between, I'll back you up even further. By mixed wiring, what we're talking about is an individual meter that is serving both, for example, an apartment, and then also maybe
Common areas.
right, the light in the hallway outside the apartment is going to the main meter, right? So there is a dispute in that hypothetical circumstance between the landlord and the tenant with respect to how much of the individual meter is the tenant's responsibility versus the landlord's, right?
Correct.
So,
or in some cases, right, that because, houses have been modified over time, it could be that one tenant, when they, switch off a light in the hallway, it could switch off another tenant's light. So non-exclusive use of
Yeah.
electricity.
I actually live 48 Sherman Street, Hartford, Connecticut, has this issue. Eversource, check it out.
Duly noted.
Law school. Upstairs, anyway. So, but given, like, this comes down to, these are can be contentious situations between tenant and landlord. And I imagine the reason I was curious about this response is that it seems to me that UI wouldn't get involved necessarily in the dispute about what proportion of a meter is attributable to the landlord or the tenant. Is that correct?
We don't get involved in the dispute. What we do is we go out and confirm that there is non-exclusive, use, and then is incumbent upon the landlord to remediate the situation. So.
And if they don't, then we advise that we'll put the responsibility for the service in the landlord's name. And then
Okay.
subsequently, then you have the landlord paying for the service. And then if they don't pay and you shut it off, you're going to shut off the service to the tenants.
Understood.
Like I said, it's not a common occurrence. It just was one of the items that was recognized that might come up.
Thank you. And the last bullet point on here is for partial payments. So those are circumstances where someone might be eligible for disconnection, but has made a partial payment, which protects them from disconnection. Is that accurate?
Right. So the balance is growing, but they are paying enough in order to avoid the disconnection.
Okay. So I still am just curious why, like, I understand all of these reasons, but I still don't understand why the company wasn't able to identify an attachment 1 to OCC 828, like which of these reasons or any other reason applies to a particular account.
We can. It just at the time and the turnaround time of the interrogatory, we weren't able to look at every single one of those
Okay,
accounts at that time. But
okay,
we could, and we are looking at we do review the list. We are working them. But at the time that we were asked to supply the reasons for each and every one of them, we didn't have sufficient time to do that.
okay. So I would like to ask a late file, but I'm sensitive to the fact that the late file deadline is similar to the turnaround time for an interrogatory. So I
Yeah.
want to explain what we would be interested in primarily is the split, is the, how much of at any given time and the accounts that are eligible for disconnection but haven't been disconnected, how much of each of those, for instance, like what proportion of that is because of lack of AMI as opposed to partial bill, as opposed to split wiring, and whether that would be easier to do as a representative example, like to go through this exhibit and label them or not. That's my question to you.
Do you mean this particular list?
Well, no,
Because,
because
we, as you know, we have, thousands of accounts and, some of them subject to disconnection could be a large number that we're not disconnecting.
sure.
Yeah, one moment. Yeah, I think just to clarify, understanding the subset that you're interested in, to look them up is a manual exercise. So you have to look up and see, when the last activities were, last payments, et cetera. So it's doable, but I think the population is what the question. So as we've discussed, there are, many customers that are eligible for disconnection at any given time, especially now that we enter into outside the moratorium period. So to look up every individual account and understand why they weren't disconnected would be difficult.
Would it be easier to do it for the spread for OCC 828 attachment 1 since that list already exists?
Yeah, and what we could do is do a refreshed list because that list is at this point potentially different. So we could either use that list and give you an update on each one of those. That's possible.
Sure. I mean, yeah, I mean, I think I'd leave it to the company's discretion, given to we recognize that there are some things that are not possible in the amount of time that you have to give us that. But that sounds great. I mean, if we could ask for a late file where as much information as we could get that indicates like the proportion of reasons why outstanding.
Yeah, we could take that list and go through the list and get an understanding of why they weren't disconnected at that time. And then we can give an update as to their current status.
Thank you. So Chairman, could that be late file, whatever number we're on?
We're at late file exhibit 7. And the interog was OCC 28, correct?
828.
828. Thank you.
Kim White issued hundreds of interrogatories in this case. I had one question about OCC 828 attachment 1. Column B shows revenue class categories, and it looked like that was mostly split between residential versus commercial and industrial, but I think there's an account where the category is miscellaneous.
Sorry, I missed the reference.
828, it's OCC 828 attachment 1.
So your question was on the miscellaneous categorization?
Yeah, I was just curious what that means, like what a miscellaneous.
There's a couple of different potential categorizations that could fall into subclass. So it could be a house meter, it could be private area lighting. There could be, it's so clearly not residential or commercial, but those are probably the two most common examples would be a house meter of some sort or private area lighting.
So we could validate that.
Okay. Sure, that would be help. So if on late file 7, if you could also just add like what the miscellaneous accounts or account are, that would be helpful. I mean, just a narrative describing the kind of account it is, not that. Thank you. I'm gonna move on to some questions about OCC 674.
Yeah, I've got that one.
Okay. So this response explains how the company was conducting its customer satisfaction surveys using outbound calls prior to 2023. I'll start there. Is that accurate?
That's correct.
Okay. So were those outbound calls? Those are calls from the company to customers?
Correct. And not from the company, it's from our third party CSAT provider.
Okay. How does the provider pick which customers to contact, or did the provider pick which customers?
Yeah, so we take all of the interactions received within our CRM database and provide that to the third party organization, and then they randomize the selection and make phone calls until they get enough to reach that quota.
Okay. And what are those calls structured like? Like, does the representative read a script? I guess how scripted are the calls?
Yeah, they're entirely scripted. So, and I'm sure we've provided testimony with the question set that's utilised. So it's structured with an introduction and consent to have the discussion, and then they flow through the contact satisfaction question, which is how satisfied were you with your most recent interaction, and then we have a verbatim discussion with the customer to try and get more insight. And that's the piece that's really important for us, because if a customer scores us as unsatisfied or satisfied, we really want to understand the details of that interaction and how we can do better or celebrate the performance of that interaction.
Okay. And sorry, did you say a verbatim conversation?
Correct.
So is that still, what does that mean? What does a verbatim conversation mean?
So we would ask the customer to elaborate on their score. So can you tell me what you are dissatisfied with in regards to that interaction, or what made you fully satisfied?
Okay. And this response, OCC 674, discusses how the company the company's vendor, it sounds like, I guess I'll back up. When the company switched to email surveys, was that the same vendor?
Correct.
Okay. So there was 10 months, the company changed for 10 months to conducting email surveys in 2023, right?
11 months.
Okay. Was that like a full switch to emails, or was that like a pilot, like some of it email and some of it were phone calls?
Yeah, no, it was a full switch to emails.
Okay. And the response says that the test concluded at the end of 2023 when it was observed that the scores dropped significantly due to the survey distribution channel. What does survey distribution channel mean in that?
So that's email versus
The use of email versus voice that the score dropped.
because of the test. So the question set remained the same. So if you think about the variables that you have to change there, in this case, the variable that changed was the distribution channel.
But couldn't one variable that changed have been the satisfaction of customers?
Not to that extent, absolutely not.
Okay. And why do you say that? Like, why couldn't it have been?
It's because we've at the United Illuminating, we've had consistently strong performance in regards to customer satisfaction, utilizing our data and benchmark, as well as external sources such as JD Power. I mean, through that period, in the last 3 years, we've gone from 11th place in JD Power in regards to our league table position in the Northeast to now 5th. So we've increased on customer satisfaction during that period.
And what are those JD Power rankings? What data is used for those?
It covers, I think it's 6/7 best practices. So it'll look at customer service, power quality, reliability, billing and payments, pricing, and one or two others. But it covers a 360 view of the customer's engagement and level of satisfaction with the services that the company provides.
Is that data from the customer satisfaction surveys?
Sorry, could you clarify your question?
To the extent those rankings measure customer satisfaction, is it measuring the satisfaction using the data from the customer satisfaction surveys that the company performs?
So there's two different survey tools. One is JD Power, which is managed externally by JD Power. And then there's the contact satisfaction surveys, which are managed by our third-party survey company.
Okay. The response also says that one of the reasons for discontinuing the use of email surveys was the associated costs. What were the associated costs of using email surveys?
So email surveys are typically a more cost-efficient means to get access to a higher number of surveys. The challenge we found with the email surveys is one, we were not getting customers who are not digitally engaged. So if you think about those customers who would typically not respond to email surveys, voice-only customers, these customers were not in that population. And then the kind of second thing is the conversations that our customer satisfaction partner were having with customers to get more details on why they're either satisfied or dissatisfied. They were far richer than what customers were responding to in emails, because it's a conversation. You could say, well, why did you not like that? What happened? How could we do better? And the insight was far, far richer.
Yeah, I saw those explanations also on here, but I'm still confused about why associated costs was listed as a reason to discontinue email. Like, were there higher costs for the email surveys than for the phone surveys historically?
Costs were similar.
Okay, because it says, additionally, the exclusion of non-digital customers, comma, the associated costs, comma, and the opportunity to obtain in-depth conversational insights, et cetera. So why does it say associated costs
Yeah,
here?
so good question. So in regards to when we filed our prior UI rate case in Order 40, came back with a mandate to ensure that we continued to do our existing surveys. At the time when we filed, that was the voice. the associated cost to carry both voice and email would have been cost prohibitive and made little sense.
Okay. I guess this is a question perhaps, well, I can ask the panel, but I have a feeling Mr. Hurwitz might answer it. Were the costs of the customer satisfaction surveys in the test year different than the costs incurred in 2022 or the cost proposed in the rate year in this case?
I can offer that the test year amount for these costs was derived, excuse me, the rate year amount for these costs was derived by taking the historical test year and escalating it by the general wage inflation factor. We provided historical information that predates the test year on Schedule C 3.03, so you can see the line and do the historical comparison. We provided in I want to say it was OCC 70 information regarding 2024 costs, but I don't recall whether these particular costs were itemized in that document.
Okay.
That was a little rambly, but I think that.
No, I understand. Well, and you probably already understood the reason I was asking is it sounds like the test year practice in 2023 is now going to change into the rate year. So, and it also sounds like there wasn't a K&M, a known and measurable adjustment, that there was just an inflation factor applied to test year costs.
To my recollection, we did not apply a specific known and measurable for this outside of the application of a general inflation escalator.
Okay, thank you.
If I could just go back to Mr. Patterson's comments and the questioning around just the change in methodology and the impact to score, just to kind of help illustrate Mr. Patterson's point. You know, we do other surveying types across channels, and one of them is the ability for customers to opt into a post-call survey when speaking with a customer service representative, and those scores overall contact satisfaction. It's the same question on the survey score that our third party does for us. You know, our achievement has been over 90% on that question to customers who contact us. You know, with nearly a 10,000 surveys conducted throughout the year. You know, just to illustrate that, you know, the channel that the customers are receiving the survey does have an impact on the result from the customer.
Thank you. So telephone surveys continued in 2024, I take it?
Exactly, yeah.
And I saw on this response that the performance, the scoring for 2024 was consistent with previous years, but did you provide the 2024 scoring anywhere in this case?
I can provide it now if that would be useful.
Sure.
So yeah, this going back to the same delivery methodologies 21 and 22, the scoring was just double check with my.
And while Mr. Patterson is double checking that, I led you astray a moment ago on my reference to OCC 70. I intended instead to reference OCC 556 UI Supplement Attachment 1. And that document at numbered line 8 reports 2024 customer service outside service expenses. So this is all customer service outside service expenses, not just this one particular line item, but it reports overall customer service outside service expenses of 6.643 million, which is more than the rate year amount of 6.491 million that we're seeking in this case.
Thank you. And we will forgive this one instance where you failed to remember an interrogatory number off the top of your head.
I appreciate that very much.
Just to clarify, so confirm it's 90.2%, 90.2.
90.2.
Correct.
Okay. Thank you.
Welcome.
I have some questions about CAE 5. Attachment 1. Purist staff was asking some questions about this yesterday.
All set.
Thanks. I'm looking at the second tab called cost components. A number of these projects have a cost component that's called system integrator. Can you explain what that is? I can give you like a specific, like row 14, for example, on the spreadsheet.
Attorney Wheel, you referenced CAE 5. Did you instead intend to reference CAE 50?
50, yes. Thank you.
Does that earn me a second?
Yes. Yes. You just absolved yourself of your failure to remember a single interrogatory. Sorry, CAE 50, attachment 1.
Yes, we have it. Yep.
Okay. So again, I'm looking at the tab labeled cost components. And for example, on Excel row 14 for the bill redesign project, there's a cost component called system integrator. What does that mean?
Yeah, I believe that's the vendor that we worked with in order to execute the bill redesign.
Okay. So looking at the TOU assessment project, which is project 5836, starting on Excel line 24. The two costs for this project are internal salary and then a one-time vendor cost.
Attorney Wheel, that particular project may be better discussed during the capital panel when we have support from the IT folks who can help speak to that.
Okay. I was actually going to ask, I had my general questions here were why are some of these projects capital projects at all as opposed to expenses, but I can ask all of those to the capital planning panel if that makes more sense.
That's probably appropriate. I can speak to some of that, but I would anticipate needing to rely on my colleagues to some extent.
Okay, sure. I'll shift those questions over. I did have a couple of related questions, which are mostly follow-ups to what was testified yesterday regarding this and related exhibits. But if these are also better for the capital planning panel, just let me know. The authority staff yesterday had questions about which of these projects were complete, which I interpreted to mean in service. And the company responded that only the bill redesign project is. Is that correct?
Yes, I'm just looking at the LIDR. I don't know if that was on the other list, because if that's the 2-tier, then that would be complete as well.
Do you know the project number for that, for the LIDR 2-tier project?
I don't offhand. I see the project ID here. I just need to validate that.
So is that the Rider LIDR project? That would be for the 2-tier?
Yes,
Okay, so that's project number 3947 on this.
that's what I see on this spreadsheet, yes.
Okay. This is probably a question for the capital panel, but that project is listed on the company's most recent plant supplement to CIP 4, supplement 4 as in service. So I guess again, I could ask the capital panel, but would that indicate that that project is also in service?
Yes.
Okay, thank you. And some of the are the all of these projects are listed on CIP 5, which is the documentation for plant that was expected to be in service at the time of the original rate case filing. So the reason I'm hesitating is that it was forecasted plants in the past, and some of it is, as we've just discussed, has now become plant in service. But all of these are expected to be in service in the rate year, is that correct?
Yes, I think I'm pretty sure as well we've provided testimony with the forecast for each of the programs and a timeline in an interrogatory.
I'm specifically curious about the Green Button Connect project, about the implementation, the expected implementation date for that. Do you know offhand when that project is expected to be live, like in service?
Yeah, I think we've provided testimony to the fact that we do not believe that the Green Button Connect would be in the customer's best interest in regards to cost and value.
Okay, so is that project canceled?
We're pending direction.
Okay. Because this is probably a capital planning panel question, but OCC 884 has an attachment that shows the IP3 approval status of all rate year projects. Some of those are indicated as canceled, but the Green Button one is still slated for expected approval on January 2026. So
yeah, the project's not cancelled. We've been asked to provide costs in a recommendation, and we've done so. So it would make sense to ensure that it's included for now until directions finally given.
okay. Well, and the original reason I was asking the question is because I noticed that project is on this attachment and is still pending approval, and that approval isn't expected until January. I was just curious about the timeline of implementation. It's my understanding that no expenditures can be made until that IP3 approval is approved. So how long will it take, if the project is approved, how long will it take to finalize it? Do you have a sense?
Yeah, again, I'm sure we've provided expected timelines. If you just give me a second.
Sure.
So it starts Q3 26, end is Q3 28.
Okay. So that then wouldn't be in service within the rate year then, right? If it's not going to be final until 2028?
Yeah, based on the recommendation, well, the direction we get from the proposal that we've kind of put forward, there would be incremental phases of implementation for that program, which would be in service as part of the rate year.
Okay. I also noticed the Energy Manager Enhancement Project doesn't yet have IP3 approval according to OCC 884. Is that project expected to, I mean, is there a similar uncertainty about the future of that project?
No, it's a project we've proposed as part of this rate case.
Okay, but you're just mentioning before that it sounded like Green Button Connect, there's some internal uncertainty about whether that's
No,
going to be approved.
It's not internal uncertainty. We've given feedback to Pura that we don't believe it's the right thing to do for the customer based on the cost and the benefit.
I see, okay. Okay. So outside of that, I guess as a general principle, although the Energy Manager Enhancement Project hasn't yet been internally approved, the expectation is that the level of plant that the company is seeking within the rate year will reflect the level of plant for that project that's in service in the rate year. Is that?
Correct, yeah.
Okay. Thank you. I noticed that CAE 50, the narrative request itself, was asking for all expenditures, customer service expenditures that affect the revenue requirement request in the instant proceeding associated with customer service initiatives. But this response doesn't include any OpEx, is that correct? Like these are, the response is only providing capital expenditures?
I think I can speak for the digital aspects of it. So yeah, they're capital programs, and we capitalize, for example, if it's a SaaS license for a platform, then that would it could also be capitalized over a multi-year position. So they're capital projects.
Thanks. Yeah, I understood that. My question was more, as I read the request from Pura staff, my understanding of the interrogatory request was for the company to identify all costs that are requested to be in the revenue requirement associated with customer service, which I would expect that to include operation and maintenance costs like compensation and benefits for customer service personnel, outside services for customer service vendors. So that's what I was just curious. I guess, did the company see the interrogatory request differently?
Reading this again with fresh eyes, I see why you asked this question, but we did read this as related to capital. There's a schedule within the revenue requirement, Schedule C 3.03, that provides all of the OpEx associated with all outside service customer activities. And whether that counts as an initiative or not, I don't know. It's not super clear to me if we continue including active and final collection costs in the rate year, because there were some of the test years that count as an initiative. I'm not sure. We read this question as relating to our capital projects because that's what we saw as initiatives. But could we have provided all information about all things that relate to customer service in any way? Maybe.
Okay. So the company would, I guess, object if we suggested that this was a waiver of the request to recover all of the O&M associated with customer service in the rate year?
We are not waiving
Okay.
that request.
Thought I'd give it a shot. Thank you. The last question I have is, Mr. Daniels, you mentioned yesterday in the context of retaining customer, there's some questions about retaining customer information, retaining the physical documents or not. You mentioned that there's a plan to upgrade the SAP system. Is that pending? I was just curious about whether that plan, that upgrade, is part of the revenue requirement in this case, or if that's a longer term plan.
It's a longer term plan. It's not included in here.
Okay,
There have been some preliminary discussions because it will likely be initiated in other Avangrid Networks companies first. So there's been some discussion around record retention in general and of all the companies.
okay. Because I saw, this again might be for capital planning, and that's fine. I saw a project, there is a project in the rate application, project number 2860. It's labeled SAP HANA or HANA upgrade. Do you know what that is?
I mean, that is the larger project. I'd have to consult with our IT partners to understand that. Maybe that's some preparatory work or something.
Okay, I could also, I'll try that again at the capital planning
Okay.
panel.
Do you repeat the number of the project you just mentioned?
Yep, it's 2860. I am also like assuming that I'm not adding all the zeros in front of the 2860. That I'm assuming that's also probably how the company thinks of the project numbers. And that was my last question. But that was the last question for this panel from the OCC. Thank you.
Okay, thank you. Then let's go ahead and transition to the cross-examination by the EOE, and we can probably get in 45 minutes to an hour before we break for lunch. Attorney Venora did.
Yeah, I just have one procedural question or a procedural matter I wanted to raise before the EOE's cross.
Okay.
I think maybe it'd be best to let them get situated at the table because they,
Okay.
I don't want them, I want them to be able to.
Sure.
sit. Okay. I just, thank you, Chairman Gillette and Commissioners. I just wanted to note for the record before EOE commences its cross, that UI had previously issued discovery to EOE consisting of 10 questions. In UI, EOE set 3 that largely related to customer service issues. EOE did not respond to the discovery and filed an objection on April 7th, which was docketed as motion number 93. UI filed its response to the motion on April 14th, and to date, Pura has not ruled on the objection or compelled EOE to answer. And just to clarify for the record today, by going forward with EOE's cross of the customer service panel, the company maintains its positions as stated in its response, which is that EOE is a party and should be compelled to answer the discovery. And simply that by moving forward today, we aren't waiving any positions that we've set forth in our response to EOE's objection.
Understood. And I thought we had ruled on that motion, so I can definitely look into the status of that. But Attorney Lopez, do you have a response, or I can just note that for the record?
Just briefly that EOE stands on its objection.
Okay.
And I have one other, maybe simpler thing. So we're just trying to plan for our next panel, which is the comp and benefits panel. EOE's reserved about 5 hours of cross, and maybe at the lunch break, we could assess if that's, a fulsome.
I was going to start this off with saying, good news, this will not take 5 hours.
Yes.
By no means. It should be a few hours, but
Okay.
by no means that long.
Yeah, we certainly anticipate heading beyond the lunch break, but
Okay,
we were overestimating
got it.
to be conservative.
Okay, thank you.
Okay, so, let's see, it's 11:30. And everyone else for this panel has reserved their right. I think I have 3, 4 questions if they still stand. So it sounds like we may begin the comp and benefits panel today.
And that's fine. We have them on call.
Okay, very good. Then let's aim to get that started before we adjourn. So anything further before? Okay, so Mr. Ogieri, are you starting?
Mr. Lindy is going to start
Ah,
first.
very good.
It's okay. It's okay. All right. Actually, I'm going to start, Tom Lopez, on behalf of EOE. And I'm starting because I just have the smallest amount of questions, I believe. So, if you could, and good morning, commissioners and to my colleagues. So I want to focus your attention on EOE 194, if you could. And you note, and so we asked about this customer appeared to have pre-qualified for hardship based on his answers to the call. And during the call was cut off. And we asked whether the company subsequently called the customer back. I guess my question is that you say that the customer was called back, the CSR called the customer back, and the pre-qualification conversation for financial hardship designation did continue. And that the customer was provided with an email address to send the necessary documentation. So I want to skip to the end and then I'll sort of get to the questions. It says that the I-Core CSR on this call no longer supports the UI credit and collections program, which we understand. What I did want to ask, though, is that the customer did email documents, and there was a next CSR that designated the customer's account as hardship and lighter tier 1. Was that, it says next CSR, was that also an I-Core CSR?
We would have to double check on that. I believe that was the case, subject to check.
That's fine. If it's a read-in, that's completely fine.
I'm sorry, so you want to read in F confirmation as to the employee status?
Yes, please.
Okay.
And I just quickly to follow up with that, it said that the next CSR incorrectly informed the customer that they would be eligible for the BFP until after May 13th, 2024. Would you happen to know the date of when that occurred?
The date of the call with the next CSR?
Correct.
Yes, we would be able to provide that as well as the status of the employee.
That would be perfect. It can be the same read-in as opposed to a separate read-in. That would be very helpful. Thank you.
Okay.
And that's all I have.
Good morning. My name is Ezra Lindy. I'm from EOE. My first question is referring to EOE-4. And it's, what does the company do in cases where the customer states that they never received the notice in the mail? And if a termination notice is returned by the post office as address unknown or undeliverable mail, is that service termination canceled? If not, why not?
I can answer probably the last part of the question first. The time it takes for the return mail to get back to the company, there's a lag time there, and it's generally more than 30 days. We don't get, if a post office return occurs, we don't get that mail back into our center to either correct the address, research the address, for, beyond the time that a service disconnection would have happened, right? So the customer would get their notices, their final notice by the time that we get the return mail back. A service disconnection, if it were to take place, would have already happened. As far as the first part of the question, when we get post office returns, the CSRs goes through a series of steps to, one, if there is an address available, a forwarding address, they'll make that change. They'll also make sure that they'll do a Google search of the address to see if there's any particular formatting issue that might be causing the mail to be returned. And additionally, and a recent implementation by the company, we automated the process for post office returns. Now, it doesn't impact every single post office return, but we do, through our vendor that provides bill print for us. They have information from the post office, so we get a file, and if there is an address mismatch or an address change needs to be made, that's automated now. And we're just reviewing the report to make sure that the system automatically made those changes. So that should effectuate some quicker timing on that. However, I do not believe we would get that in time to take any action before potentially disconnecting the customer.
So the first part, so say a customer states that they never received the notice in the mail, what's the process for that?
So the very first step, and this is before we would even potentially get into a conversation with the customer, through the verification process, we would verify the customer's address. So we want to verify both the service address as well as the customer's mailing address. So that's done that's a requirement on every call as part of the verification purpose. If the customer let in with I didn't receive a shut off notice and I was shut off, we'd want to confirm, one, that the notice was mailed, to ensure that there's no systematic issues with notices going out. And then two, we would look to confirm the customer's address to correct the address as necessary if there was an address mismatch of any sort.
We also would like to encourage them to take advantage of the other tools that are available. So in the My Account feature, you could see any shut off notices. Also, we send text message at the time of the shut off as well. So if for some reason we don't have a valid mobile cell phone number, we'd encourage the customer to add one. Otherwise, they would also get a text message warning of a shut off notice.
And as far as the text message are concerned, we've seen tremendous adoption from the customers on that to date since we've launched text messages for disconnection notices via text. Less than 1% of the customers have opted out of that notification method. So it's definitely something that customers appreciate and that they find useful.
Thank you. My next question is referenced in EOE 12-12. Does the company anticipate that at some time it will reinstate the non-residential security deposit program? And if so, does the company have any timeline for its reactivation?
We do anticipate reactivating and we don't have a timeline at this point.
Thank you. Next question is referenced in EOE-14. Does the company have the ability to reschedule a missed appointment for the same day if there is still time remaining within normal business hours?
Well, I think it's a general practice that if there's a potential for a missed appointment, we notify the customer of those circumstances and try to work with them directly to accommodate them the best that we're able to, and understanding the needs of their particular schedule.
Hi, Brittany Wyman with EOE. I apologize for doing this. I'll try not to do it frequently. So in your answer, were you talking about if a customer missed an appointment or if the company is the one that missed the appointment?
So the company response is
Regarding,
company missed appointments.
just want to make sure. Thank you.
Yes.
Thank you. Next question is in reference in EOE-15. In regard to section C of the company's response, if the company knows in advance that an appointment is going to be missed, how soon does it notify the customer to advise and reschedule?
Well, I think the first step that we endeavor to take is we look to find another resource to complete the work. And if for that reason, if there is no additional resources available, if there's nobody working in the area, obviously working to limit the customer impact. When we find that resources have been exhausted, it would be at that point that we would attempt outreach to the customer to notify them of the potential for the missed appointment, and then work with them to reschedule if necessary. But I think it would vary depending on the steps that the company goes through to make sure that we're meeting appointments as scheduled, and also depending on the resourcing available that day. We may have to go through several steps to find an employee who's available, figure out what they're currently working on, when they can get there, all those sorts of things.
So next question is referenced in EOE-31. And the company's response states that the company includes this payment option within periodic bill insert communications. Does this insert also include the list of third-party walk-in payment agents / locations? Over the course of a calendar year, how often is this bill insert included with this bills, both paper and electronic?
Just in reference to the list, there's hundreds of payment locations, so there are links to the list. And then I think they're checking on.
Is the actual, I'm sorry, Frank Algieri, EOE staff. Is the actual list ever provided in paper?
I don't believe so, no, because there's literally hundreds and hundreds of locations that they can pay at.
If a customer wanted a copy, could they get one?
I suppose. I'm not aware that they've asked for one, but yeah, I would imagine it would be possible.
Yeah, and so it's updated on a monthly basis on our website as well, so customers can get visibility of those.
Thank you. All right, and my final question is in reference to EOE 56. Within the company's response, there is the use of the term life support medical protection. Does this term, life support medical protection, mean the same as the term life-threatening situation as used in the Connecticut general statutes? If not, what is the definition for this term? And why not use the same language as found in the statutes?
Could you confirm the number again?
EOE 56.
For some reason, I'm not locating it. Okay, could you repeat the question again, please?
Yeah, so it's basically just addressing the company's use of the term life support medical protection. Is that the same thing as life-threatening situation as used in the Connecticut general statutes?
Mr. Lindy, could you just identify which statute or statutes you're referring to?
Yep, section 16-262C.
Thank you, sir.
D1.
Okay, so we use the term life support when there's actual equipment in the home, just so we have that as a delineator. And then the other term is life-threatening, which is also, those both would get the same year-round protection. So I suppose we could unite them and have them one, but just historically, we've delineated the life support, meaning they have equipment in the household.
So that would also mean someone who is documented that there is a life-threatening situation.
Yeah, so they both would get that year-round life protection.
Thank you.
Okay, good morning, Franco Jerry again, EOE staff. I just want to go back on one answer that you gave to Mr. Lindy. That was to EOE 4. Mr. Daniels, I think you were talking about that there might be a timing issue in when the company finds out if there's something, a notice that's returned for either address unknown or undeliverable. Is that correct?
Correct.
Okay. I'm just curious, the response in EOE 4 says the company matches daily the number of termination notices scheduled via Dunning jobs in the system against the number of termination notices mailed through the company's billing services vendor. So that doesn't have any influence on returned mail.
No, so that's what that's making sure is that the number of shut-off notices that's generated from the system, that's the number of pieces that are being mailed. So the number that's going out the door. So we want to make sure that those match, because that would, if they didn't, that would indicate some sort of a mailing issue.
Okay. So that daily check would not catch on anything freshly returned from the post
Correct.
office.
It's a numbers comparison. Are the number of shut-off notices that should have been generated, were those the number of letters that were mailed?
Okay, thank you. I'm going to move on to EOE 113. The bulk of my questions are going to have to do with telephone conversations with credit and collection. I know that we might have been using terms. I just want to make sure we're on the same page with some of the acronyms. CSR is Customer Service Representative.
That is correct.
MPP Matching Payments Program.
Correct.
BFP Bill Forgiveness Program.
Correct.
LIDAR, LIDR, Low Income Discount Rate.
That is correct.
Fantastic. EOE 113, please.
I have that up.
Okay. So just a general question regarding conversations with the CSR. If a customer is determined to be apparently eligible for hardship during the pre-qualification process, that doesn't enroll that customer onto hardship. That customer still has to submit documentation.
Yeah, pre-qualification and documented hardship are, two distinctly different things. The pre-qualification is a customer attesting on a call that they are eligible for hardship protection. However, the account would not be hardship coded until we received documentation to substantiate that.
Okay. So at that point where the customer appears to be hardship via pre-qualification, the only payment plan a CSR can offer is the flexible payment arrangement?
So until a customer is documented hardship, right, they would not be eligible. Now it would be just the matching payment program. So until it's a documented hardship case, a flexible payment arrangement would be the only plan available to them, other than budget billing if the customer happened to not be past due.
Right, right. And that's how you train the CSRs. They're trained to offer that flexible payment arrangement in a situation where they are apparently qualified for hardship.
Well, at certain times of year, it offers the customer some protection because they're not hardship eligible, say, outside of the moratorium period. We could protect their service from disconnection by getting on a payment plan, which would allow them time to send in hardship documentation. And at that point, once it's a documented hardship case, then we would be able to enroll them in MPP.
Okay. So the flexible payment arrangement, this is a plan structured so that the customer pays the current bill plus an amount towards the outstanding balance, correct?
That is correct.
Okay. And it can be up to 18 months.
That is correct.
Okay. And there's no matching element to a flexible payment
There is not a
arrangement.
match associated with a flexible payment arrangement.
Can you compare how an MPP arrangement compares to a flexible payment arrangement in terms of how the monthly payment amount is arrived at?
So a flexible payment arrangement, again, it takes the past due balance or the arrearage, it amortizes that over 18 months, and then adds that to the customer's current bill. So they have basically, for all intents and purposes, a loan for their past due amount. That loan amount gets added to their current bill amount. So in the instance of MPP, what we do is we take an estimate or an average bill amount, typical or similar to what we would do with budget billing, where we establish a budget each month for the customer based upon historical usage. The customer pays that budgeted amount. The payment that they make, any payment they make, including SEEP awards, would be matched towards their arrearage.
Okay. So let's focus in on the customer in EOE 113. As stated in the response, the CSR had identified the customer as a hardship and also on the Tier 2 LiDAR, which is the 50% discount. If this customer or any customer is identified as such, would they be eligible for MPP?
Once it's been substantiated through documentation, yes. The low income discount rate also brings another component into play here, because the budget amount that's going to be set up on MPP is going to take into account the customer's rate discount. So based upon hardship documentation, a customer could qualify at this point in time either a 10% or a 50% discount, which would significantly impact the budget that would be set up on that account. So having the proper documentation and having the correct budgeted amount for the customer, is essential. And we need to make sure that we code the customer on the appropriate tier by substantiating their hardship through documentation.
Also noting that there's a balance requirement for the MPP program. So it's $100, 60 days. That would be the other review.
Are the CSRs trained that if they see a customer is already on the tier 2 LiDAR, that they are eligible for MPP?
If a CSR, in order for a customer to be on LIDR tier 2, their hardship would have to been substantiated. So at that point, they could enroll the customer in MPP. They would not need to submit any further documentation.
Okay. So if the CSR sees on that customer record that they're tier 2 LiDAR, should they be offering a flexible payment arrangement to that customer?
Likely, I'm trying to think of a scenario where that could possibly be the case. But again, I think what's important is, has the customer provided documentation? Has their hardship protection period expired? In that case, if they're active on LIDR tier 2, it would be active hardship, and therefore the best recourse would be to put the customer on MPP. At the time of this call, was this 2024 11? I believe so. Yep, this was 2024. Okay. So the appropriate step would be to place the customer on MPP at that point.
If I may take a step back momentarily. When a customer calls and the CSR is pulling up the screen, where is it indicated in the customer's account that they are hardship or they have lighter or what have you, whatever the designation is? And at what point can they see that information?
So when the company implemented the low income discount rate, we built out a customer protection screen within our SAP system for CSRs. So they would go to that screen to see all of the customer's protections, any locks on the account, their hardship designation, MPP enrollment, and also tier level of LIDR.
And would that information immediately pop up upon account verification?
It does not immediately pop up. What pops up immediately on account verification is the customer's identification screen, which has customers' personal information and things that would be used to verify a customer's identity. From that point, the CSR would have to go to different parts of the customer information system to find information requested by the customer or to view protections.
Okay, and are the CSRs trained to sort of do the address, phone number verification and then check to see, like go onto that other screen and see if they have a financial hardship designation?
Yeah, their CSRs are trained when they receive a customer call to first understand that they're speaking with the appropriate party. And then they should be reviewing the account, which would include interaction records, commonly referred to as notes on the account, as well as to see the customer's balance, their protections, those sorts of things, while trying to understand the reason for the customer's call.
And that screen setup been submitted in one of those documents. I know there are several sort of training materials or scripts and procedures and policies, and that screen will be in one of those. I feel like I've seen it, but I just want to make sure.
I would imagine with the information that's been submitted in this case that
Is it-
has been submitted, but I'd have to double check.
Could you double check for me
Sure.
and just let us know which one it is?
Okay.
Okay, so I'm gonna treat that like a read-in, which I believe we're up to read-in G. Just to confirm the record location.
Hardship screen? for where hardship is located in a customer's account.
Thank you.
Okay, a couple more questions on this interrogatory. Just curious, does the company keep statistics on the number of hardship customers that are on tier 2 LIDAR that have a flexible payment plan arrangement or an MPP arrangement?
I'd have to check. I mean, I know we have lots of data and statistics on, on customers enrolled in MPP, customers on LIDR, customers on flexible payment arrangements. I'd have to just double check. You're talking about potentially the intersection between somebody who's coded hardship with LIDR that might be on a flexible payment arrangement plan.
Yeah, I guess what I'd be curious to know is if the company could give us information as to just tier 2 customers and the breakdown of payment arrangements that they're on, either MPP, flexible payment arrangement, or even possibly budget billing.
By budget billing, you mean true, just budget billing?
The true
Not
budget
any
bill,
matching.
the
Okay.
levelized billing
Okay.
arrangement. Is that information the company could get?
I believe so, yes.
Okay. I'd like to ask that as a late filed
So
exhibit.
tier
please.
2
Just tier 2 LiDAR.
customers, and then whether they're on MPP, budget, or a flexible payment arrangement plan.
Correct. Or BFP, any remaining BFP survivors.
Right.
I think in this particular instance on this call, the CSR briefly explained the payment arrangement flexible payment arrangement to the customer. And there are customers and that for whatever reason, although they qualify for specific programs, opt not to be placed on those programs. We see customers relinquish their hardship status. On this particular call where the CSR briefly explained a flexible payment arrangement option to the customer and then, followed up with, I think the matching payment program will be more beneficial to you. Each customer is different. I think our interest and I think most everyone's interest in this room is to get as many customers onto a matching payment program as possible. But understanding that, certain customer circumstances and may dictate that they want to, be on a flexible payment arrangement rather than a matching payment program. I will say that our auto enrollment process would take any customer who is on a flexible payment arrangement who's coded hardship with a qualifying arrearage and automatically place them on MPP, which is helpful.
So you think after hearing a CSR explain flexible payment plan versus MPP, there might be customers who find the terms of flexible arrangement better than the MPP?
I think when it's explained, and especially the way that this particular CSR explained and noted that it would be more beneficial to the customer and included the fact that their payments would be matched. Do I see a way that any customer or could potentially get confused? Sure, there's always the potential when you're having verbal communication where somebody misinterprets something or doesn't fully understand. Those are the risks that you take when having a conversation with a customer. But I think in this particular instance, the CSR was clear on that would be more beneficial for you. And as a result, the customer did enroll in MPP.
Yeah, I was going to say, it sounds like they were successful in advising them accordingly because they did enroll in the MPP.
Thank you. EOE 114, please. The question here sort of tracks back to what we were just talking about. In the response in section B, it states that there was an opportunity to explain the matching payment program. Does that mean that your CSRs are trained to find and explain the most beneficial arrangement available?
Yes, they should be, providing the customer with the best program available to them at the time of their call.
Okay. EOE 115, please. Looking at the response in section B, if I read this correctly, the flexible plan option would be a payment arrangement that was significantly higher as compared to MPP. In this particular case, more than $200 per month.
Just for clarification, Mr. Rogeri, that's 115?
EOE 115, yes.
Okay, I pulled up 150 by accident. Thank you.
115.
In your question again, please.
So looking at the response in section B first, the flexible payment plan option would have been a payment arrangement that was significantly higher as compared to MPP. In this case, more than $200 per month. That's in the response in section B. So similarly to what I was just talking about in EOE 113, where we discussed the differences between flexible and MPP plans. We also discussed how CSRs are trained to explain the most beneficial arrangement. Are your CSRs trained to explain every possible arrangement, even a plan that would cost the customer more than $200 a month?
Well, again, I indicated that there could be circumstances for a customer where they would, for whatever reason, doesn't quite make sense to the folks in this room, I think, but they would choose another option that we wouldn't particularly view as most beneficial. And the way that CSRs are trained is to offer the best payment arrangement for the customer. And sometimes that takes a conversation to review options that are available to the customer for them to, choose the payment arrangement that works best for them. I think it's our job to guide them to the one that we think that is going to be most beneficial because we have the most knowledge around the benefits of the program for the customer.
I think you'd agree with the statement that it's up to the customer to decide what's most beneficial to them.
Would agree. But I think we should properly guide them so that they're best informed about the options and the different benefits afforded with each option.
Trying to find a way to put this. So are the CSRs trained to show the customer both arrangements, saying, here's your flexible plan. It's $200 more per month. Here's your MPP plan. It has other options. Are the CSRs trained to basically make one plan look better than the other, saying like the MPP plan offers you better incentives and better protection as opposed to flexible payment plan?
So the CSRs are trained to be able to explain all the plans, and yes, they would explain where potentially there are better benefits to receiving a match, being eligible, and or getting a SEEP award and having that matched as well, and what that does towards their arrearage.
Okay. Chair, my next set of questions is rather lengthy. Do we want to keep going on this or?
Okay, thank you, Mr. Ajari. We can go ahead and take our lunch break then, and reconvene at 1 PM.
Chair Gillette, while we break, I don't know if I heard LFE 8 officially input. I might have just missed it. Go ahead.
Thank you. I have LFE 8 listed as provide information regarding Tier 2 LiDAR customers and whether any of those customers are on a payment arrangement, and if so, what type of arrangement?
Yes, I have it. I had it too.
didn't
I
hear
had it too. I wasn't sure if we like did the whole LF,
Thank
like
you.
the
Yes,
rest
I
of
do
it.
have that recorded.
Awesome.
Thank you. That being cold. Yeah.
Yeah. Yeah, I would definitely. Oh, yeah. That is. Only here. That's true. I had that. That's all. That's fine. No problem. Just wanted to. Sure.
So that's roughly it, but, okay.
Okay.
There's been a couple of all of them.
It wasn't.
I'm just saying, because I'm sure you're going to say.
Oh, that is. I'm all right.
Okay, you can go back on the record in docket number 24-1004. Anything before we resume?
I believe over the lunch break, Mr. Daniels was able to locate read-ins F and G.
Okay, great.
In reference to F, referencing EOE 194, about the next CSR that handled the call, that was an I-Core CSR. The date of that call was March 14th, 2024. And also in reference to G, a response included in the company's interrogatories that included the protection screen would be EOE 58 attachment 1.
Okay, thank you. And just to catch up, it sounds like you all addressed read in A earlier. So I have B, C, D, and E open.
Yes, that lines up with my list.
Okay, thank you. All right, if there's nothing further, then Mr. Ojeri, please.
Thank you. Before I get back to my line of questions, I wondered if we could augment late filed exhibit 8. First of all, I didn't stipulate a time frame. Is it possible to have a time frame from January of 2023 to present? This was the breakdown of tier 2 LiDAR customers and the payment arrangements. Sorry.
No, that's okay. Just repeat the,
So the first request would be a time frame from January 2023 to present.
And just to understand intent, we're looking at customers who are coded tier 2, but on a flexible payment arrangement.
So these would be tier 2 LiDAR customers and the breakdown of the type of payment arrangement they're on.
yeah, and just to clarify, the LIDR started in December
Oh,
2023.
thank you. So let's start January 2024.
I think we're just going to need to double check what type of historical aspects of the account we would have available to us.
Okay.
So we can probably do that this afternoon. I think we could verify this afternoon. that
well,
we
this
could
would
get
be
that level of detail.
Yeah, for the late file exhibit, if you wanted to add that at the
Okay.
time you submitted the late file exhibit,
Okay.
that's fine.
Thank you.
Couple other new requests with this late file. Is it possible to provide the average arrearage per payment arrangement type?
Again, we'll effort
Into
to
that.
see what we're able to do.
Okay, and then one last request. For each payment type, could you give us the breakdown of customers that successfully completed their arrangement? And the number of those that still had an arrearage and the number of those that did not have an arrearage.
We'll see what we're able to.
Thank you very much.
Yeah, sure.
Okay, so let's get back to the interrogatories. I'm going to talk about EOE 117, but also reference EOE 154 and 148. So if you keep those 3 handy.
Could you just repeat those again?
Sure. EOE 117, 148, 154.
Thank you.
So specifically to EOE 117, there was discussion in that phone call between the customer and the CSR as to the steps a customer takes after submitting their hardship documentation. In this call, the customer stated that he had called the company in October and he was told that he should call back the following month, i.e. November, to check on the status of the documents that he submitted. So in regard to the customer's statements regarding that call in October, were those the correct instructions that he should call back the following month?
So typically wouldn't need to wait a month to call back in order to, if you submitted your hardship documentations to enroll in a program. So I would say that wouldn't have been the correct instruction. They could have advised the customer to call back likely sooner than 1 month.
Okay. So let's move ahead to EOE 154. In the response, it states that hardship documents faxed to UI are received by the internal call center. The internal call center is not credit and collection call center, correct?
That is correct.
Okay. And just a question about the process that's outlined in EOE 154. Is that process outlined the same for documents received via email?
Yes, they are. Actually, the fax documents and email documents are converged into a single queue, which will be worked through the same process by the internal CSRs.
Okay. So let's move quick to EOE 148. In the response, it states that customers do not receive an acknowledgement email confirming receipt of hardship documents. Why is that?
So what they're instructed at the time of the call is that they would receive communication from the company in form of a letter that would indicate approval or denial of the hardship documentation. We are looking at the opportunity to implement a return receipt just to clarify communications with a customer so that they're aware that the email has been received by the company.
But at the moment, there is no return receipt set up right now.
That is correct.
Okay. Just a quick clarifier on the process outlined in EOE 148.
Yeah, and also the company is looking at and has a project in scoped out for this year to allow customers with access to the internet, obviously, the ability to upload their financial hardship documentation directly to the company's website in a portal, so that they would see a positive confirmation that it has been uploaded.
Okay. So getting back to the question I just started there, are the procedures the same for a customer submitting documents via fax, that there's no acknowledgement of a receipt of a fax transmission?
It's been some time since I used a fax machine, but generally when a customer submits a fax, they get a status whether or not the fax was delivered successfully or not when using a fax machine. So they get a confirmation that it was delivered successfully.
There's no confirmation that the document is uploaded to the customer's record, though.
No, there's not.
Okay.
Other than when they receive a letter confirming their hardship status or a denial of the hardship status.
Does the company receive calls from customers saying, hey, did you get my documents I emailed or faxed to you? Is that a common question?
We do receive those sorts of calls. Our typical processing time for hardship documentation is less than 5 days. And we advise customers that it takes a few days for the documents to be processed. Some customers do call back. I wouldn't say that is a high percentage of the calls that we take. Nonetheless, we are looking at ways to improve that customer experience. One, a return receipt on email, as well as a portal where customers can upload those documents.
So how is it handled now? Somebody calls in and says, I emailed you something 2 days ago. How does that CSR locate it? What's the process to find that document?
There's a couple of different ways that they can locate it. One would be if the customer is able to provide their the email address that was used to submit the document. They can search by the customer's email address, or they can search for by the customer's account number or other information included in the email or attachment.
So do you think it would be helpful to have some kind of return receipt system set up to help expedite those types of inquiries?
I don't know that well, if you're saying expedite, meaning give the customer a quicker confirmation, then yes, I think that would be helpful. And again, we're looking into what would be the necessary steps because it's a shared inbox and there's different user rights associated with that, what it would take to put a return receipt and then have that be modifiable to set expectations for customers to say, we've received your document, our typical processing time is, 2 to 4 business days, or if it, for some reason we're seeing delays, can we modify that to say, 7 to 10 business days? Whatever would be the expectation for a turnaround time to process that document. So that's something that we're pursuing.
I want to get back to the internal call center. So once the faxed or emailed document is received by the internal call center, what happens to them? Who is reviewing them?
One of our internal CSRs. So based upon the call volume on the day, we'll either have dedicated staff that handles back office contact center work, or we'll take CSRs based upon availability and put them in a non-phone queue to perform that work where they would review documentation, upload it to the customer's account, code the account, properly according to LIDR tier, as well as code the account hardship.
Is it at this point in the process where they would be getting acceptance or denial letters for MPP or LIDAR?
So the actions taken by the CSR, whether to code the account hardship, to put them on the appropriate tier level, and if it were the case that they were enrolling them in MPP, they would receive the communications that are associated with those actions.
Let's talk about that action. The action to code a customer as hardship. They're sent either an approval or denial letter, correct?
Correct.
Okay. Does that letter also explain program requirements or any next steps the customer has to perform?
Well, in addition to coding the account, because now it wouldn't be just coding the account hardship, it would also be a coding the account with the appropriate LIDR tier level. So they'd receive that communication, so they'd know that they wouldn't have to contact us about LIDR unless they felt that they were eligible for a tier upgrade. They would receive a document to say that their hardship has been approved. Yeah, and on the second. Oh. We're checking to see the exact content that's located on we believe that the second page of the hardship letter, which we believe could contain next steps or other programs that are available to the customer.
Could we get that as a read-in? What's on that second page?
Yes.
Yes, read in H.
Do all customers get either an acceptance or a denial letter? Is there ever an instance where they receive no communications after submitting hardship documentation?
There wouldn't be an instance where they wouldn't receive correspondence from us. It would either be a denial or an approval for hardship.
Okay.
Going to save this question, but you pretty much just knocked right up against one of mine. So yesterday there was discussion about the bank statements as well. So in that denial letter, would it say what was wrong with the documentation and what they needed to supply instead?
The hardship denial letter does not give specific reasons as to why the documentation provided was denied.
Okay, but it would say
It was
your verification did not meet whatever requirement.
correct. It's your application for hardship or status is denied.
Okay, and does it guide customers to then call and figure out what's going on? I just want to see how a customer would know. I was told by the CSR I could just submit these bank documents, but then these bank documents weren't enough to verify me for financial hardship. And I'd like to hear how that customer would ultimately get notice of the appropriate documents for them, if what they believed to be or what they were told was not sufficient.
Yeah, in this instance, it would require contact from the customer back to the company to talk through the reason for denial, as well as to advise them of what they might be able to do to actually qualify for hardship.
Does the company have guidelines for CSRs to review and approve the hardship verification documents? Is
Yes,
that in the docket?
I believe so, but would have to check.
Could you check for me?
Yes.
And if it's not, if we can convert it to a save file.
Yes, we can do that.
Okay, so I'm marking that as read in I, which is the docket location. You want it listed?
Lines for the approval of hardship verification documentation.
Okay, thank you. And then if the company is unable to find that, we'll convert it to a late file.
One last question on this topic. So if there are any actions taken by the internal call center on these hardship documents, would the credit and collection CSRs see the results of those actions when they look into the customer record?
So the internal CSRs would put a note on the account for the denial reason, if that was appropriate, if there was if documents or hardship status was denied as a result of the documentation submitted by the customer, the reviewer of that documentation would note why the documents were denied.
And if they were approved, say for MPP or LiDAR, when the CSR and credit and collection calls up that customer record, they would see it. They would see that information.
Yeah, that was so that's when we were talking about the customer protection screen. Upon verifying the customer's identity, they should be reviewing the customer protection screen to see the current status of either LIDR, hardship, or other programs the customer is enrolled in.
And those actions, once they're uploaded, that's real time. So immediately the CSR and credit and collections, as soon as that's entered into the record, it would be available to them.
There is there is a note placed on the account, which is done immediately. The letter generates that evening or early the next morning for the customer, but yes, it is real time.
EOE 118, please, 118. Looking at the response in section A, it notes that the CSR encountered issues when attempting to enroll the customer. Can you elaborate more on what those issues were?
Yes, so there were some programming defects that needed to be resolved with the implementation of the new matching payment program, which went into place November 1st. The CSR in this instance, when attempting to enroll the customer, received an error message. And it was a known issue that was being debugged, and they escalated it to their supervisor because we were so that we could go back and make any changes after the fix had been implemented.
So the response where it states the supervisor took steps to resolve the issue, these were the steps to remediate those programming defects.
They weren't themselves remediating the program defects. They were they received the account information and kept the account. And once the defects had been resolved, they took steps to enroll that customer in MPP.
Right. So the issue itself was not anything unique to the customer, was a back-end system-wide issue.
That's correct.
Okay. All right, so staying with the customer in this call, it appears that the upgrade to the Tier 2 LiDAR was based on the customer documents submitted as described in Section B of the response. That date, according to the response, was November 5th of 2024. The response did not state how these documents were received. Would you happen to know how they were received by the company?
Would have to look specifically at that account, and I don't have notes for this particular interrogatory response. We can take that as a read-in.
That's okay. If you didn't know, that's fine. I'm just curious. The response states that they were received on the 5th and the LiDAR upgrade was performed on the same day. Is that a typical response time to customer documents that are submitted electronically? That same day upgrade?
Well, it really depends on time of year, resourcing, as to how quickly we're able to turn around. But I believe at that time, we were processing hardship documents same day. And so, yes, it is quite possible that a customer could send documents in and within a couple of hours, we would have processed them and performed the necessary account maintenance.
I'm sorry, I just want to go back real quick before I forget. What was the system error that you were mentioning before Mr. Jerry's next question?
Oh, so it was a coding issue. So back-end code, so you have to write code for the system to do what you want it to do.
Right.
So there was an issue with some of the code that was written that needed to be rewritten and then had to be pushed to the system in order to make that change.
What part? I know you don't know what part of the code. I'm trying to figure out how to phrase it not that way. What did this, miscoding break, I guess, for lack of a better word? Like what was the actual problem for the system besides this bad code that was in there? It's just nothing could happen? What was the actual system error? Yeah.
I understand what you're asking. I think what we may need to do is look at this particular example because there were sort of one-offs as far as maybe there was the way the account history was coded or something within this particular account that caused the bug. So there's been there was a couple of different instances where we had to fix unique circumstances. So we'd probably need to look at the specific one to understand what it was about this account that caused a bug that didn't allow it to.
Could I actually just get a list of what those bugs were? I mean, unless there was hundreds of them, if there were a few common errors you
Yeah,
found in the code, could you provide that?
Should be able to do that, yes.
Okay, so we will mark that late file exhibit 9. And this question's to the company, will it be sufficient for me to list late file exhibit 9 as provide a list of common bugs identified with the use of this code? Will that
MPP code.
thank you.
EOE 119, please. EOE 119. So in regard to the response in section B, as well as we had some discussions earlier this morning, I understand that the MPP arrangement cannot be implemented entirely upon positive responses to pre-qualification. That customer still needs to submit actual hardship documentation. So is the use of the 60-day hold or the creation of a flexible payment plan, is it to allow that customer time to get their documents to the company?
Well, the first and foremost, it's to avoid a customer from being disconnected, to protect them from disconnection. And then additionally, it does provide the customer time to submit documentation if needed.
Okay. So looking at this particular call, this particular customer, their answers to the pre-qualification questions were based on their income. So in cases of customers like this, where hardship qualification is based on income, earned income, and not upon government assistance, that customer is not likely to be reported via any type of data sharing, say from DSS, correct?
Correct.
So a customer seeking hardship based only on earned income will need to be proactive in getting their hardship documentation to the company. Would you agree with that?
Well, they would have to provide documentation to the company, yeah, and not simply, they wouldn't be coded via DSS data sharing, so they would have to provide documentation, but there are also other customers that need to provide documentation.
Generally, that customer who is hardship based on earned income, you're not going to know about that until they bring you their documentation.
Right.
Okay. So listening to this call and other calls, part of the customer ID and verification segment with the CSR involves asking about the customer's email address. These questions are either to validate what the company has on record, or if no email address is there, to obtain the email address. Is that standard practice for every call?
Part of the verification identification procedure is to, identify the customer through name, address, and last four digits of their social security number. And then we also take the opportunity to validate certain information like telephone number, email address. And if we don't see an email address, it's typical for a CSR to ask a customer for an email address to update the account.
Okay. Are the CSRs trained to always ask for an email address if one is not present?
Yes.
Going to the response in section A, it states that the customer had not submitted their hardship documentation. Does that happen often where customers are pre-qualified and just fail to follow up that conversation by submitting their documentation?
I would say that there are a number of customers each year that call us and inform us of a hardship situation that would qualify them for hardship status. There are a number of customers that either do not follow through with that process for a variety of reasons. I mean, it could be that something came up and they weren't able to do that. There are also instances where customers aren't able to provide that documentation because they don't have documentation that would support it.
So I noticed that there were several other interrogatory responses. No need to look into them at this point. EOE 120, 123, and 149, where you had a customer claiming hardship, but they never followed up with their documentation. Just curious, do customers ever follow up to determine, or I'm sorry, no, let me restate that. Does the company ever follow up with the customer as to why there's a delay in submitting their documentation?
So in cases where we place a 60-day hold on an account for a customer to submit their documentation, if they do not provide documentation, they would get a denial letter.
When would they get that denial letter? At the end of the
At the
60-day
end of the
hold?
60 days. So as a reminder for a customer to submit documentation, no, the company doesn't currently have a practice in place to remind customers that they need to submit their documentation.
And you said that's after 60 days.
Correct.
Okay. So we just talked about how during the ID and verification process, you're either checking on existing emails or harvesting a new email from a customer. Has the company ever considered issuing an email to customers to remind them about submitting their documentation if they've apparently pre-qualified for hardship, but they need to submit their documentation?
Yeah, we've actually internally talked about enhancing communications with customers via email at the conclusion of every call, actually, related to energy affordability. And even so much that we drafted a template that talks about the different programs and options available to customers, understanding that a call with the company that can last anywhere from 10 minutes to 40 minutes or even longer in some cases, for a customer to walk away from that conversation and remember everything, we think it would be beneficial to provide them with a document to reference so that they can have for the future to understand what programs and options are available to them. We're looking to implement that soon. I think we brought it up in an EOE meeting together jointly, that we'd like to review that because we think there's an opportunity to enhance customer communications that way.
So just to add to that, sorry, so as part of the prior UI rate case order 34, where we were asked to review the offline journeys for customers and how they engage with us. We've a proposal which has been submitted today as part of the Energy Affordability Working Group, which researches the needs of our offline customer segments, including the hardship customers. Based on the feedback we received at the prior Energy Affordability Working Group. And through that, there will be a number of suggestions for enhancements in those areas. So it's something we're actively pursuing just now.
Thank you.
And I just want to circle back. We did receive confirmation that when you place a K hold on the account, a customer is sent, that triggers a letter to be sent to the customer, letting them know that documentation is required for hardship.
Okay. EOE 125, please. I know I asked you in regard to EOE 14 if the customer, the CSR is trained to find and explain the most beneficial arrangements. In regard to the response on 125, does this include a direct comparison of the different flexible payment arrangement or MPP arrangement, the amount, the monthly amount that would be paid?
Yeah, and just in reference to the conversations we had about 114 and 115, I believe, just to clarify what the training is, the training for CSR is to offer the best available program for the customer, which in our estimation is a program that matches their payments, that gets their arrears down more quickly. In the instances that we talked about before, I think the CSRs acted in a way that we were trying to be extremely helpful to the customer, perhaps overly helpful, and didn't necessarily need to go into flexible payment arrangements on those calls, but did in an effort to be as helpful as possible. When it comes to this instance here in 125, CSRs are trained that if a customer has questions, detailed questions about the different programs, that they can in detail be able to explain the differences between the programs and the benefits, and they have tools available at their fingertips to be able to research those and spell that out for a customer.
Thank you. EOE 147, please.
I have that up.
Okay. I think I'm reading this correctly based on the file name of the recording. The date of this call is November.
That is correct, November 6th.
Okay. It says at the time of the call, the customer was enrolled onto Tier 2 LiDAR. Do you know when the customer's enrollment onto the MPP program was?
Subject to check, I would suspect that this customer was enrolled on November 1st as part of auto enrollment because they received SEEP the previous year. But would have to look at the account to confirm.
So would knowledge that the customer was on Tier 2 LiDAR been enough to initiate the MPP arrangement when the customer called?
So at the time of this call, if the customer is on Tier 2 LIDR, yes, the customer could have been enrolled in MPP at that time.
And the SEEP commitment would not, oh, I'm sorry, go ahead.
Yeah, I'm just, like I said, I believe the customer at the time of the call may have already been enrolled in MPP at the time of auto enrollment, which took place on November 1st. And then the company does recalculate SEEP, MPP upon a SEEP payment.
Right. The monthly amount would have been recalculated.
Correct.
On SEEP commitment.
Correct.
Okay, thank you. EOE 149, please.
I have that.
Okay, so looking at the file name of this recording, this is a January call, January 22nd, correct?
Of 2024, correct.
2024, okay. Response states, let me restate that. Is there a time limit on asking the pre-qualification questions? The response state, the customer called on the 9th, but that the CSR should have re-asked the pre-qualification questions. In this case, that's the 22nd. So is there a time limit on asking the pre-qualification calls? So even if the customer calls on consecutive days, do you want that CSR again asking pre-qualification questions?
Yeah, so the, you know, on each call, in accordance with the live call guidance, that we should be attempting to pre-qualify the customer. And it could be as so much as, has anything changed with your financial circumstances since the last time you called us? But, you know, we should be asking pre-qualification questions whenever, those elements of the call, if it's a customer with a past due balance or, having a difficulty making payments and they come through our IVR, through the credit and collections pass, that we should attempt to pre-qualify customers.
So if it's not stated on their customer record that they're qualified for hardship or on MPP already, if they're calling, say, on consecutive days or even on the same day, that CSR should be looking into the pre-qualification questions for that customer.
We should be attempting to pre-qualify customers on every call.
EOE, oh, I'm sorry. All set? Yep. EOE 150, please.
156, you said?
I'm sorry, 150. This is a real simple question. If you look at the response, the first paragraph, the sentence ends from LiDAR tier 1 to tier. I'm assuming that should say LiDAR tier 2?
Yes.
Okay. EOE 152, please. In section B, it states that CSRs can view most letters. Can you elaborate on what types of letters is included in the most category?
So letters that are generated from the customer information system, as well as letters that are sent through our bill print vendor. They can either view those documents within the customer information system or in the billing management system.
So what is not included in the most category?
Likely be one-off sort of letters directly to customers. If a customer's receives a budget billing letter, that letter is not currently available to CSRs to view.
Is it possible to change this so the CSR can view all the letters sent to a customer?
Yeah, that exception is being addressed. We're transitioning our correspondence. So that will be included.
Any timeline for the implementation of this?
Yeah, I think we've started the transition. I believe it's going to be completed by July or August of this summer.
EOE 155, please. Looking at the response in section A1, It notes that if documentation is being submitted for MPP enrollment, callback would be necessary. How does a customer know to call the company back, or when to call the company back, or what number to call? Is that something that's in that approval letter?
Yeah, it would be appropriate for the CSR to explain to the customer that after they have sent in their documentation to contact the customer service number for next steps.
Okay, so earlier we talked about the response in EOE 117 where the customer was, when he called in October, was told to call back in November. And I believe you said that's not the correct procedure. Is this
Well,
something different?
I think what I was trying to indicate was that the duration that the CSR provided to the customer for the timing of their callback wasn't appropriate, given the length of time it generally takes us to process hardship documentation. It was appropriate for them to indicate to the customer that they would be required to call us back for the next steps.
So that customer is told verbally on that call, you need to call us back, and this is when you need to call us back.
Typically, a CSR would advise the customer to call us back in a week to a few days for next steps on their account. Or if we needed to wait for their next meter read date or after their due date, the CSR would advise them appropriately about the timing of the next call.
I know we talked about potential uses of emails. Is this a subject that could be enhanced by using an email to the customer, providing this information?
I believe that there's several opportunities to enhance customer communications from emails, and this is likely, one area that could be improved.
So I was just going to add that the customer communications is a topic of research within the Order 34 proposal for the Energy Working Group.
Okay, thank you. EOE 190, please. Within the response, it states that the CSR missed that the customer's account was already coded hardship and on LiDAR, and additional information was not necessary to initiate a BFP arrangement. So during the time that this call happened, did the company have a means to check if there are customers enrolled onto LiDAR but not onto BFP or NPP?
Can you elaborate what you mean by a means?
Would there be a potential for a LiDAR customer not to be enrolled into either BFP or NPP?
There's a potential for a customer to be on LiDAR and not be enrolled on BFP or MPP based upon the arrearage on their account. They may not qualify for an arrearage program, even though they are on the low income discount rate.
Would that typically be the tier 1 LiDAR customer?
There are customers that are on tier 2 that do not have arrearages. So it could be either.
does the company have a means right now that shows the number of tier 2 customers that are not on MPP or flexible payment arrangements?
I mean, I would imagine we'd be able to create reporting to sort of related to your late file request.
I'm just curious, the late file exhibit 8 that we were talking about earlier, is it possible to show the number of tier 2 LiDAR customers that aren't enrolled in any type of payment arrangement? With,
Yeah, I mean, we can include that in our review. I would imagine so, yes.
okay. That'd be great if you could add that
Okay.
metric to it.
Yeah, and I think some of these nuances where customers may qualify for particular programs and not necessarily be enrolled, we're now addressing with our, biannual MPP auto enrollment. And now that BFP is no longer in existence, a customer who is on tier 1 or tier 2 identified as hardship, at some point in November, we're doing an auto enrollment for those customers with qualifying arrearages. And then similarly in the springtime, sometime in March or April of each year, we're going to do another auto enrollment so that we would capture any customers who've provided hardship documentation, since the November auto enrollment to get customers on MPP.
Okay, thank you. I'm all set with that. UE 193, please.
I have that up.
Okay, in this call, the states that the CSR was eventually able to educate the customer on how to submit documents electronically. And listening to these calls, you occasionally encounter customers that are not technologically inclined. So just curious, what would have happened if that CSR was unable to help that customer? Is there anyone else that could intervene on behalf of that customer? Does the company have resources that could?
Yeah, I think that's detailed in our, in our escalation process and procedures, and CSRs are always encouraged, regardless of length of tenure. If you find yourself in a situation where you're unable to help a customer, and maybe it's as simple as just you're not able to get on the right communication path with a particular customer, that you should seek to escalate and find additional resources to assist.
Okay, thank you. EOE 196, please. Within the response, it states that the company system automatically recalculated the monthly BFP amount due to the customer's enrollment onto LiDAR. When it did that, it increased the customer's monthly payment an additional $93. Response further goes on to describe how or why the enrollment onto LiDAR resulted in the increase to the monthly payment. It also states how the original $145 BFP amount was established as an exception to provide an affordable payment arrangement to this customer. Now, understanding that BFP is no longer in use other than people still on it, was there at that time any kind of, or even now, any kind of notation or indication on the account regarding the exception process to prevent this from happening to another customer. You used an exception process to lower the LiDAR amount to a lower arrangement, but the LiDAR, automatic adjustment for LiDAR changed the amount. So I'm just wondering, do you have the means to prevent that automated change in the monthly payment in cases where you've made an exception for energy affordability?
So are you talking about, in this case, on a moving forward basis for this?
Either currently or moving forward.
Well, I think, I don't know that I fully understand the question. I think in this instance, what occurred is, the customer's amount was changed. It was deemed unaffordable by the customer. That matter was escalated to a supervisor or a higher level employee where we were able to look and see if there was something that could be done on an exception basis for this customer, and that should and is our practice is that when there are, extenuating circumstances impacting a customer, that we need to stop, we need to escalate, and we need to, find out if there are any other opportunities to assist the customer, in this case, to achieve, a more affordable payment arrangement.
Right. Yeah, I guess that's where I was going with this is there was a manual process to adjust the BFP process, the BFP amount. So knowing that there's a manual process to adjust the monthly payment, is there some way that this system can recognize that so an automatic change, such as the LiDAR recalculation, is not automatically triggered?
So I think BFP was unique in that could potentially result in a recalculation that was higher. I'm trying to think of a scenario with MPP where if a customer received a tier 2 upgrade, unless their consumption increased significantly, I don't know that I can think of a scenario where a customer upgraded to tier 2 on MPP and received a recalculation, would see a higher budget amount.
Do you think this was unique to the BFP program and customers on it?
I believe so.
One last item on this call. Within the response, it states that the customer had requested to speak with a review officer, but that request was not honored. In this case, a supervisor intervened in the matter and was able to resolve the dispute involving the payment amount. So just curious, when a customer requests to speak with a review officer, what is the process used by the CSR to initiate that request? Who does that request go to?
So it would go to the next level employee, whether it be a lead or a supervisor, in an attempt to resolve the escalation for the customer. Understanding that there's an extremely finite number of review officers employed by the company. We don't want to inundate them with those requests if it can be resolved by another employee.
So the procedure includes that opportunity for the next level escalation staff to try to resolve it and not put extra burden on the review officer.
That's correct.
And if that intervention was not successful, it would then get
It would continue
transitioned.
Yes.
Okay. Last set of questions, EOE 201, please. And you touched upon this earlier with some of your responses. In EOE 201, it stated that during a period between March 11th and March 22nd of 2024, over 2,200 hardship documents were processed. There's just one staff member doing this, or was this one of the times that you added staff?
No, we have multiple CSRs who either are assigned to back office related work, in particular the hardship queue on particular days. And as there's availability with call volume, we'll attempt to add additional staff to keep that response time as low as possible.
So you have the ability to add or decrease staff depending on volume?
Correct.
Okay. So during the moratorium period between November and May, on a weekly basis, what's the average amount of hardship documents that are submitted, either email or fax, or combined email and fax?
The average monthly amount?
Weekly. Or month, if you keep monthly stats, that's fine. I was just curious.
If you wouldn't mind me taking a read-in, I have our correspondence report that I could refer to. We publish weekly, which would indicate, I can give you last May through November's average weekly processing time.
That'd be great.
And volume.
Yep, that'd be fine.
Okay.
Just clarifying, is that a read-in or a late file? I think that's at the company's discretion.
I can read it in file. I guess we could take that as a late file, probably be easier to.
Okay, so that will be late file exhibit 10. And I apologize, Mr. Ogier, if you could summarize for me one more time.
It's weekly average amount of hardship documents submitted to the company.
By channel or just?
Combined. It doesn't need to be broken down.
And it, like I said, it goes into one queue, so.
Okay, thank you.
So in regard to the volume, has the company seen a downward trend in submitted documents because of DSS data sharing?
No, at this point, there hasn't been a downward trend in documents. And really that's to some degree process driven as new enrollments of LIDR are placed on tier 1 and then required for a tier upgrade to submit documentation. So we haven't seen a downward trend in documentation. We've actually seen the opposite, I believe.
Would you know or be able to find out how many of those documents are simply to go from a tier 1 to a tier 2 and not just to be certified hardship?
I don't believe I could provide that level of detail.
Okay.
And just one last question. You talked about how it's more than just one person processing these incoming documents. Can you tell me what's the average number of people that are working on those assigned to that task?
It would depend on the.
Would it help to include this in the lay file exhibit?
Sure, to the extent that we can get an average number of CSRs that were working that queue that on a particular day, I believe we could provide that.
Okay. That'd be great. That's all I have.
I'm sorry, is that a late file exhibit or a read-in?
I think if we could include it in late file 10.
Okay. I apologize. This may seem like it bounces around because it does. It's mostly focused on interrogatory order, of which kind of jumps everywhere. So I'm going to start with EOE 58 attachment 2. And I did quote what I'm going to ask about, so I'll quote it and then you can let me know if you still.
What was the reference again?
EOE 58 attachment 2, page 1, technically. There's a section that's called Alorica CSR expectations. And the expectation is to transfer all customers who have an arrearage balance or who indicate they are struggling to pay to their bill for financial hardship. And any questions or concerns should also be, the call should be transferred. So who are they transferring it to?
So I believe that's for the move-in, move-out agents
Okay,
that handle only move-in, move-out calls at Alorica. So if they receive a credit and collections related call, they would transfer that to another Alorica agent who is trained to handle credit and collections calls.
okay. So at any point in time, I'm moving into a new place and I either have a bill transfer or I indicate at the time of setting up my new account that I might have difficulties.
It could
They'd
be
set 'em
that
up with
or simply you select the wrong option in the IVR.
Okay. Okay. EOE 64. You don't really need to look at it for this. This question is going to sound sort of pedantic and a little silly, but I'm going to ask it anyways. The company mentions that, as we all know, for BFP and for new MPP, a customer must have an arrearage of 100 days that is 60 days older or more. Can you just define that for me? Like 100% of the $100 has to be over 60 days old. A portion of the $100 has to be over 60 days old. It has to be just $100 a total and $1 of it could be 60 days old.
Yes. Yeah, whatever is in the age, if you look at them in aging buckets, you got your current, your 30 days, 60 days. So in the 60-day bucket, we're looking for $100 plus.
So when a CSR looks at the customer's account, they'd see those buckets
Yes, they would.
and say I'm on day 61. Would that show in there if I called and I'm now 61 days, it just immediately transfers to that next
Yeah,
bucket?
there's no lag. It's real time.
EOE 136 attachment 1. This one you may want to look at. It's the energy affordability training module. At the beginning, there's just a list of different greetings that the CSR must make, when they answer the phone. How did the company come up with these greetings? What was the process?
I'm sorry, Ms. Wyman, did you say 146?
If I did, I meant 136.
Could you help and point me to the page that you're referring to?
136 attachment 1. And it's called the energy affordability training.
I have that and I'm just looking for.
Let me try to pull it up.
Oh, the greetings.
It looks like you may qualify those sorts of ones.
Gotta find the exact verbiage here.
I just generally, there's a few of them. What was the process the company took to determine that those were the appropriate greetings?
Well, I think, within our management team and quality assurance team, there's a significant amount of customer service and contact center experience and most often we're relying upon the experience of our management team members and experience in working in contact centers and communicating with customers, and also understanding the expectation of the CSR to come up with language and scripting that can be easily adopted and also, meets the need of the requirement to engage the customer.
Can you point to the, what exact
I'm trying to find that as you were.
Is it at the beginning, like page 5 or?
It is, 36. This is what I get for trying to save computer battery and not have it open in advance. UV1.
Well, I
So I mean, it starts on page 5.
The items in like the green box, the suggestions. Okay, I just wanted to confirm what you were referencing.
So I understand you're saying there's various experience that kind of led you here. But was there a process? Did you review PURA guidelines as you were coming up with these? Was there a committee? Was it single person? I'm just curious about what you did.
Yeah, I mean, like the guiding factor is always the live call guidance for the energy affordability calls. So we want to make sure that we are compliant with the requirements, and then I'll allow others to chime in. But I think then that it's a collaborative effort with the training and quality teams who listen to calls and perhaps have suggested approaches to make sure that they meet those requirements and giving suggestions about how they might perhaps follow up on the call.
Yeah, and I think you're also, whenever you're trying to introduce scripting, you're trying to use language that can be easily adopted by CSRs and also easily understood by customers. So, we do go through revisions of, proposed scripting, and generally our quality assurance team will propose scripting, and then it'll be shared amongst management team members, and we'll make edits or red lines or suggested improvements, all as Ms. Blah indicated, keeping in mind that, we want to meet the requirements of live call guidance.
Thank you.
And we're also trying to, at the same time, deliver a positive customer experience where, where we want a customer call to have a natural conversational flow, because, that can lead to a more desirable experience for the customer. So you're really trying to balance all those things.
Thank you. And are CSRs required to explain all the different payment arrangements? And I'm gonna say now, so starting Alorica. Are they required to explain all payment arrangements, even if the basis for the call is not to get on the payment arrangement? Say it's to pay their payment arrangement, or they wanted to know how much they need to pay. Are CSRs required to explain every program anyways?
If they're already on a payment arrangement, the expectation would be that they confirm that the customer understands, the details about the arrangement that they're on.
Okay, because I saw on, it is page 11 in that same document, that the rep suggestion should say, now that we've covered our assistant programs, let's take care of the original reason for your call. And I wasn't sure if that set that expectation that regardless of the reason for the call, in the white, right under the first green bar.
Yeah, I mean, as it says, it's just a suggested transition because they are, when they receive the call, they are looking for the opportunity. If the customer's owes a past due balance, they're looking for the opportunity to pre-qualify them for programs. So if they have the opportunity to open the call doing that, and the customer perhaps has said, when they greeted them, they said, oh, I want to make a payment. They might see the past due balance and say, I'd like to make sure you're aware of the programs that you may be eligible for. They transition into that. And then there's this is like a suggested transition statement to help them transition from what they just spoke about to the original comment that was introduced at the beginning of the call.
Yeah, and in general, the scripting that we provide CSRs is not a verbatim requirement. This is a training and guidance document to help CSRs be able to use language to help them transition in certain scenarios. So it's not a requirement to say this the exact way that it's written here.
Okay, thank you. And so that would go for in EOE 136 attachment 2, which is the energy affordability scripting. That's the suggestion, right?
Right. Those are suggested scripts, for CSRs, they are welcome to use that scripting. But as long as they meet the requirements, that the information is conveyed to the customer in a way that, is easily understood, that, they don't have to use that exact language.
And for that script in attachment 2, what was the process for that to be drafted?
Again, most of our live call guidance and job aids and those sorts are drafted by our quality assurance team, with an opportunity for revisions across the broader management team.
Who makes up your quality assurance team?
So we have a quality manager that supports all operating companies across all states. And specific in Connecticut, we have 3 quality analysts. I think one is UI specific, the other 2 are UIL. And we now have a speech analytics analyst and a knowledge-based base analyst.
I know you touched on that somewhat yesterday as well. Okay, moving on, same document. On page 2, it has a note to check for important notes, and then quotes, it says top 100 red flags. Is that a list that's provided to CSRs?
So the red flag is actually indicative of, there's a type of interaction record or note that can be left on an account that is called a red flag. And the reason why is if you look in the notes, you'll see that interaction record up here in bold red. So that would be an indication for the CSR when reviewing accounts.
Okay, so the top 100 means what to that?
So those are high balance collections accounts, where, the company's actively trying to engage customers because of the
Okay.
classification of their arrearage.
Yeah, there might be an indication that something special was being worked on for that account. So to make sure that they look at it before they start embarking on, conversation about plans or payment arrangements, there might already be something in action. So they want to look at the notes to make sure that
And that's just
they're not conflicting with something that's already being worked on.
and that's just in the notes that we've been talking about.
Yes.
On page 5, it states that LIDAR for rate RT should is applied to the highest rate first. Am I understanding that correct? So there's an on-peak and off-peak rate, and the LIDAR discount is first applied to the on-peak usage, and then whatever is remaining of the 1,200 kilowatts, it's then applied to that.
Yes.
Okay. Can you tell me what Pura decision indicated that that's how the RT rate should be applied, the LIDAR should be applied to the RT rate?
It sounds like we may have a motion ruling related to that we just need to look up.
If you want to do a read-in for that, I'd appreciate it.
Okay.
I believe that's read in J.
Thank you. Okay. UE 137, which I'm also scrolling to. Now I tried to organize my notes so that this is all just easy for me, and of course, that's not how that works. Okay, so I put on page 27, it says page 25 on the top, so I believe it's a attachment. It says, ask the customer how much of the required payment. Oh no, I smushed two of my things. Okay, there it is. So in your answer, the company states that, no, I just can't understand what I wrote. I apologize. I'm gonna ask it this way and not refer to the interrogatory. I believe there's a procedure, or is there a procedure for the customer that when they're setting up a flexible payment arrangement, the CSR should ask how much the customer, is able to pay?
No, I don't believe we have any training material that would reference that. They would be going by the flexible payment arrangement guidelines. Likely what you may be referring to is customers who have broken multiple arrangements, and at that point wouldn't be afforded an arrangement at the original down payment amount where we would ask for a larger down payment to be able to get them back on arrangement.
I'm just move on. I might come back at the end. UE 138 attachment 1, the EA live call guide, and it's end of moratorium scenarios. It's also attached. There's also another one, attachment 5, that is the UI matching payment program eligibility enrollment. For attachment 1, do you know what date?
I'm sorry to interrupt. Can you repeat the
138.
138
Attachment 1.
attachment 1? Thank you.
What was the date of that? And I guess more importantly, has it been updated?
But I don't know the exact date at the moment that this was created, but also do know that it has been updated.
Is that somewhere in the docket? Because I didn't see it, but that doesn't mean it wasn't there. And essentially what I'm looking for is the winter moratorium's going to end, what, 2-3 days from now? What sort of guidance have they been given in preparation for that?
Oh, okay, sure. So actually, I'm losing track of days, but last week, last week
29.
Last week, I held all employee meetings for both our internal and external centers on April 25th, where we reviewed guidance on the end of moratorium. We covered a host of topics, including MPP and flexible payment arrangements, LIDR for the electric utilities. We also covered equal opportunity for employees and customers, soft skills, a host of topics for a training day that we conducted between the hours of 9 a.m. and 4 p.m. On April 25th.
Okay, in UE 178, attachment 1, there's an end of moratorium training for the 2023-2024 season. I assume it's something like that.
Yes.
Okay. Do you have a did you make the 2024-2025 season one? So if it enrolled in November, the winter moratorium is now done in May of 2025. Is there an updated version of that end of moratorium?
Yes,
Okay.
yes, there is. Yeah,
Okay.
so there will be a new training
a new
material
training,
each year.
yeah.
So we, twice a year, before the end of moratorium, typically the last 2 weeks in April, and then before the start of the winter moratorium, typically the last 2 weeks of October, we hold all employee meetings with both our internal and external centers, and we review program year changes, guidelines, all the relevant information in one group meeting live in person for the CSRs that are located in Connecticut, and then our partners at our vendors, in this case, Alorica, join us virtually on Teams. And we have a whole day of training around a variety of different topics, but specifically around the hardship program year, as well as the end of the winter moratorium.
Okay, and that includes all the new MPP rules.
Yes.
Has that been submitted into the docket? I looked for it, I didn't see it.
I thought we had submitted the October one, but would have to check.
I say it could have been me. There are a lot in here. If you don't mind, I know that you updated an OCC one, but I didn't, and you referred to that in one of the EOE interrogatories, but I didn't see the updated version, or at least I could not find the updated version. I was gonna laugh if Frank is pulling it over. If you could let me know where that is.
I actually don't believe it is in the docket.
Oh, then can that be submitted as a late file?
Sure.
Okay, so late file exhibit 11, Attorney Wyman, if you could summarize, please.
The end of moratorium training for 2024-2025 season.
Training documents.
Training document.
For the 2025 to 2026 season.
Or no, 2024 to 2025, since the winter moratorium is ending now.
Understood.
Just for clarification, you're looking for the material that was presented last week?
Yes. Maybe that's the easier way to put that.
Okay.
Okay. We are on EOE 138 attachment 5. It's the UI matching payment program eligibility and enrollment. On page 5, it states UI will auto reinstate customers on MPP every November 1st, regardless of when they were previously enrolled within the previous program year. Is that correct?
Yes.
Does that include customers who previously completed MPP, but now meet those requirements, eligibility requirements? So 6 months ago, they didn't have an arrearage. They graduated from MPP and now you're back to auto enrolling?
Any customer with a hardship, financial hardship designation and a qualifying arrearage would be automatically enrolled. So
Okay.
yes, a customer in that instance would be enrolled.
Okay, and I think I heard earlier that if they were on a flexible payment arrangement, they would be taken off that flexible payment arrangement, put it on.
Yes, they would.
Okay, and that's for the new MPP?
That is for the new MPP.
Okay. I'm gonna move to 139. In that you were explaining that to avoid disconnect, a customer is able to pay a 20% of what's owed in order to avoid disconnect. That's correct.
Correct.
And I think how many times do you allow a customer to do that? So this would be without enrolling in a payment plan?
Yeah, so
for one reason or another.
twice per year, once from a CSR and once that can, one time that can be automatically done through the IVR.
How does through the IVR, so a customer pays 20% over the phone and the system automatically
Correct.
recognizes that it was that much and then would stop the termination at that
That is
point?
correct.
Okay. So there were a few introductory responses that stated that the company does not offer a hold for customers to provide financial hardship verification documentation outside of the winter moratorium. That's correct, right? The company does not offer that.
That is correct.
Was that always the case?
Yes.
Okay.
As far back as I can remember.
Okay. There was never a 7-day hold for customers outside the winter moratorium to provide? I know that's medical too.
That was for medical.
Okay. In EOE 139, attachment 1, page 10, there's a little chart that has all the different sort of blocks that the company offers. One of them is an N lock, which is for 10 days, and it's locked in denied/incomplete hardship requests. What's that? And when does that get implemented?
What page is that on?
It is page 10 of attachment 1, 139.
And which lock are you asking?
The N lock?
N as in Nancy.
N is in Nancy. Nope. Yes. It says denied incomplete hardship request.
So in instances where we place a hold on the customer's account to allow them to send in documentation, the N lock is a system generated lock that gets placed on the account after that period has expired. It sends a letter with an additional 10-day hold for the account to allow them and to let them know that they haven't provided the hardship documentation as requested.
Okay, so some of the questions in discussion you're having with Mr. Algieri about how the hardship documentation verification process goes in those rejection letters. It's that rejection letter after the 60-day hold or any time hardship documentation gets rejected?
It's actually both.
It's both. Okay.
The N lock triggers that letter to go out to the customer.
Okay. And then they get another 10 days as a courtesy?
Yes.
Okay. You don't need to look at these, but in EOE 213, 226, and 230, there was an error with the DSS data matching where there was an address mismatch that occurred. Company's been looking into that issue. Is that correct with the DSS data matching?
Yes, I think there was some confirmation on the matches.
Right. Has the issue of the address mismatch been resolved with DSS?
I'm not sure that there was an issue. I believe that they confirmed that particular instance, but let me just check and see if any of my colleagues know any more detail. Yeah, I don't believe that there was an issue. I believe we just were confirming how the DSS data match worked. And in that particular example that we were reviewing, that the address did not match. And
There,
so
there was never an issue where the company listed addresses or wrote addresses slightly differently than DSS?
I believe in the early stages, yes. Unfortunately, my colleague who investigated that is not here today, so I could get a little bit more detail on the particular situation.
Could I get a late file on the address mismatch with DSS data matching? What the issue was that occurred and what the status is on that issue and if it's been resolved?
Yes.
Okay, thank you. That is late file exhibit 12.
Thank you. Okay. First. So EOE 221. There was, I'm not sure I asked my question well enough. I believe in this call, the customer had a flexible payment arrangement, had signed up for a flexible payment arrangement and paid their $25 deposit. Prior to them making their first payment, well, they missed their first payment after the deposit. The customer called back and they were able to do another $25 deposit to start a new flexible payment arrangement. Is that process correct?
So a customer would be afforded the opportunity to have two flexible payment arrangements at that $25 down payment amount.
Okay, so instead of, they wouldn't be required to make up the missed payment, they would just be able to do another $25 down payment.
Yes. And then if it were to happen again, there would be a different requirement.
Okay, in that scenario, usually, and you can correct me if I'm wrong, the $25 down payment happens the following month. I know it depends on when the meter read is, but it's usually not due that day. It's usually due for the next month's payment.
They need to make it before the next meter read data.
Okay, but then that next meter read date, they don't have to pay their first installment yet. Is that correct?
Well, it would depend on there's two types of payment arrangements that a CSR has the ability to utilize. There's one that requires a down payment, and there's one where the initial payment is not required. Let me just confer with a colleague on that for one moment. Yeah, so typically the $25 payment would be required within the current billing cycle with their first payment arrangement amount not being due until they receive their next bill.
Right. So I guess my concern is, and I should just explain it, and not a concern, it's my question. Could there be a 3 or 4 month period where a customer signs up for a flexible payment arrangement twice, never having made an actual required monthly payment, but just have done two $25 down payments?
May need to clarify this for, so you're asking, can a customer call, make a $25 payment, get set up on an arrangement, not pay the flexible payment amount, call us back after the arrangement has broken, but before disconnection, and re-enroll in another flexible payment arrangement, making only a $25 payment?
Right, although I think I've seen the disconnection is concurrent with the second flexible payment arrangement.
Say that again?
They had not yet been disconnected, but they received a disconnect notice.
Sure.
When they called to set up the second flexible payment arrangement.
Yeah, so we would allow a customer for those two occurrences, you can have two flexible payment arrangements within a year, whether they occur back to back or other times in the year. Yes, they would be able to get out another flexible payment arrangement, twice within a year, regardless of the duration between the two arrangements.
Thank you. So moving on, yesterday you had a conversation with Attorney White on customers only being able to enroll on MPP, the old MPP, if they had previously had a SEEP payment or they had a SEEP commitment at that time. Is that correct?
So customers who had received SEEP the prior year would automatically be enrolled each year.
Right. And if I were,
If you were a new
Hmm.
candidate for MPP, a requirement for SEEP or a SEEP commitment would be required to be placed on MPP.
okay. So what time of year do customers apply for SEEP?
SEEP applications begin generally September.
And when do you normally see SEEP commitments coming in?
We don't process them until November 1st.
The commitments?
Correct.
Or you mean the MPP?
Yeah, the commitments are processed and that would capture, so in addition to customers who are auto enrolled because of participation with SEEP the previous year, we would also capture any new folks in the auto enrollment process at that time, on November 1st.
Right. So,
And then periodically throughout the winter moratorium, we will receive updated commitment files, which will result in an auto or enrollment of those customers. Well, the old way anyhow.
okay, so you do the auto enrollment in November and when else the old way?
So we only did the auto enrollment in November with old MPP. Now we
Okay.
do it twice per year. But a customer who received SEEP would be enrolled in MPP at the time that we received and processed the commitment file.
Right, but they may not have gone, how long, what's the last month that a customer can apply for SEEP?
They have until May 31st of each year to apply for SEEP.
Okay, so in theory, a customer could be hardship, have an arrearage for old MPP, gone to a CAA and applied for SEEP, but the company wouldn't know about it yet. I mean, if your auto enrollment's in November and they didn't go till December, January, February, March, they wouldn't have been picked up in that auto enrollment. Is that correct?
They would have been picked up with the commitment file because we
As soon as you get the commitment file.
yes.
Okay. But they could never have enrolled prior to them getting that commitment file. Ignoring the ones who had SEEP and were on MPP the prior program year.
Right, so a customer with a hardship designation would not be enrolled in MPP until we receive the commitment file.
Even though they had an arrearage. Even if they called and said, I have an arrearage, I want to make a payment plan. I would love to be on MPP. You would not then enroll them because you do not have yet
Well,
have a commitment file for them.
It was a requirement of the program to be on SEEP to receive.
Was it a requirement to be done by phase one, the end of phase one? That they had to have SEEP by the end of phase one?
in order to be enrolled for that program year, they would have to have done it before. And we would go back and enroll customers after May 31st if we received late commitment files. So if a customer waited until May 31st to apply for SEEP and was granted SEEP, and we received a commitment file in June, we would have enrolled that customer in MPP, and they would have been required to make one payment to remain on MPP through phase one.
Okay. I'm gonna move on.
The new version is a lot better.
It is nice. Monthly matches works well. That's good. So I'm on my last home stretch, ish. OCC 10, it is all the vendor contracts. I can give you a second, but it's attachment 18. I have a question for, it says that what was provided was the second amendment to the master service procurement agreement, but I did not see the actual master service agreement in that filing. Or the First Amendment for that matter. I couldn't see the scope of services in that Second Amendment. I would just like it provided. That's it. I don't need to ask questions on it. I would just like.
Can you just, you said attach
Attachment-
OCC 10 attachment 18?
Yes.
So that's the contract, I believe, with Intrado.
Mhm. What services do they perform?
Intrado is our high volume call answering solution. So in the event in a major storm or other impact to the company, we're unable to either handle all the calls that are coming in, or for some reason our phone lines are down, we're able to forward calls to this high volume call answering solution to eliminate the possibility of a customer getting a busy signal when they call us.
Okay.
Frank probably recalls they used to be called 21st Century.
I can that just get submitted as a supplement? I just didn't see the master service agreement in there.
The original master services agreement.
It just, the Second Amendment to what I saw didn't list the scope of work
Yeah.
or some of the other
Yeah,
finer
we'll
details.
submit it, and I'll let you know they've been purchased a few times since then.
Name changes.
Mosaics, message broadcast.
Got it.
So it gets a little confusing, but we do have an MSA.
Thank you.
Okay, Attorney Wyman, that was OCC 10, is that correct?
OCC 10 attachment 18.
Attachment. Okay, just for consistency, I'm going to label that late file exhibit 13, and I'll say to refer to that, provide the master services agreement.
And the amendment number 1, if it's still valid or effective.
Good, take a look.
I also saw OCC 10 attachment 21. It's Agile Development Services. Can you tell me what services are provided? Yeah, OCC 10.
Just bring it up. Yeah, so these are professional services to help deliver our customer experience programs across the company. So project managers, scrum masters, business analysts, etc.
And
Capitalized projects.
what type of services do they perform? How do they assist the company?
Yeah, so they would help, for example, on the delivery of, yesterday we discussed the moving home project, where we developed new capability on our website for customers to move in, move out, transfer service. So they would support the collection of requirements, help with the solution architecture, and then the overall delivery of the program.
Okay. Sort of consultants that are always there to sort of assist you with different tasks
Yes.
or changes that you're trying to make?
Yeah.
And are those services provided to all of Avangrid, all of Iberdrola, UI?
To Avangrid.
Avangrid.
And then it, again, specifically if we have programs within UI, then for UI or otherwise.
Are costs associated with this contract included in this
Yeah.
rate case? Wait, how much of the costs are being sought?
It was, so where you see within the capital program budgets, professional services for the digital programs.
Would this be more appropriate to ask in that panel? I just want to know what percentage of the costs were allocated to UI for this rate case of the overall cost for this contract.
Yeah, just yes, I think within CA 14 attachment 1, we break out those costs for each of the programs.
For this contract specifically? Or
Yeah.
just for each program?
Yeah, I'm just trying to give you an example that could kind of bring that to life.
I'm happy to re-ask this to the other panel if that's more appropriate.
Yeah, I mean, I think it would most likely be myself if you're looking. So within CA 14, attachment 1, you'll see each of the external costs in there, and they're a mixture of either software costs because we need new technology to do something, or professional services costs. But if they ask us to, within those professional services costs, to then do an allocation of split across that specific vendor, then that's.
Is this company paid per project or just every month as a standard fee? What are they?
These projects are capitalized at a project level.
Right.
Yeah.
And their pay is considered part of that capitalization?
Yeah. Yeah.
Okay. I think I'm okay for now. Thank you.
Okay, thank you.
You could refer to OCC 839. You provide percentages of customers who took action after each termination notification step. Were all of these percentages relative to the customers receiving SMS notifications? And when in the termination process do they receive the text message?
So we don't necessarily have the ability to correlate action taken by the customer via communication channel with the customer. I think this response was more of an indicator that our overall communication strategy with our customers and the various channels utilized results in relatively high at 71%, percentage of customers that took some sort of action to prevent disconnection. But the ability to correlate by channel what motivated or made a customer make or take action, we just can't make that correlation. The technology just doesn't exist.
Okay. In what step in the termination process does that text message go out?
It happens. Turned myself off instead of on. It happens in conjunction with the shut off notice. So it's like you would get your you would get your first bill, you'd get your next bill next month with a past due balance. 5 days later, you get the shut off notice and you'd get the text message at the same time.
You're mailing it and sending the text on the same day. So the mail they may not get for 2 to 3 days, but they get the text message.
No,
first.
it's the same same dunning step, so it's the same day as when the mail would be sent
Right,
out.
but the
Or you
customer
could,
wouldn't receive, if it's a letter, the customer wouldn't receive.
correct.
But if it's an email, well, no, even then it's still a letter.
The customer would also see it online on the website.
Yeah.
So even though the mail may take a couple of days, the customer can view that online.
Thank you. I only have a few more questions. And these are going to seem a little more jumbled if they haven't been already, because this is mostly based on yesterday conversations. So yesterday you were explaining about the AI data analytics, and how that's sort of working with call tagging in a gross simplification of what you discussed yesterday.
I recall the topic.
And I think you ultimately said that there was an FTE that was working, that was hired to work on this. What software are you using for this, or company? I wasn't sure.
So it's a Genesis SpeechMiner product.
It is the Genesis. Okay, so that's one of the contracts that's provided in UE 10.
Yes.
Okay. And are there special protections to keep customer information safe? Since the way AI works is it takes the data to learn.
So this this particular product is different from the product that we're going to, which will be more AI driven. This product works off of.
I can probably speak to this. Just that's on the AI steering group with the company. So yeah, the product that was referenced yesterday in regards to the knowledge-based product where we do have AI just now, that's not customer specific information.
Okay.
Yep.
Is the newer AI that you're transitioning to going to have customer specific information?
Exactly. Where we're moving to is where with the new telephony platform, we want to use AI to help with the call analysis. So we'd look at call scripts and then identify key trends and feedback that can help us improve and make learnings.
That will be with Genesis as well?
No,
Or a different company?
it's a different vendor.
And do you already have a contract with them?
We have a contract and we are in the process of implementing the initial phases. The initial phase doesn't include the Gen AI capability. That would be a later phase. And as a company, Avantgrid is establishing policies around data protection and the use of Gen AI to protect our customer data, our company data, and everything in that regard. We have a risk board, which before any Gen AI use case would be allowed to be promoted to a production environment. That risk board would then evaluate each of those use cases, technology, the contract of the vendors, or policies, etc. Before that could actually go live.
Would you know this early on, I guess, if the company that you're using would use the information you're putting into the AI for it to learn for their own purposes?
Absolutely not.
Okay.
Like any LLM model we use is ring fenced our own company.
Okay. All right, this is still gonna bounce around a little bit. Also, yesterday, you were discussing the call review meetings you have with quality assurance and different, you're reviewing the calls after they've been reviewed, et cetera. How does that work in those meetings?
Yeah.
So we call them call calibration sessions. And what we do is we have our quality team lead those, and they will choose calls that have already been reviewed by either the internal supervisors or the external QA analysts or the external supervisors. And what we do is we already have a call that's scored. We go through it as a team and rescore it. And we can compare that. We don't like to call anybody out individually, so we don't do that. But our goal is to maintain a 5% or less variance in what folks are scoring. So we It's a very robust conversation, lots of opinions, and we try to narrow it down to black and white as much as possible. And so we found it extremely helpful to keep everybody on the same page.
And perhaps maybe what you were referring to as well, I was talking about the joint meetings that we have to review the results. So you want to talk a little bit about that, the vendor and
Yeah.
meetings that we have with them where they go through all the KPIs, the quality reviews.
So we do have a formal meeting every 2 weeks, and it has senior leadership on down to center managers, QA managers, workforce management on the Alorica side and on our side. So you might see 30, 40, 50 people on there. And Alorica prepares the information. They go through all call center KPIs, staffing, forecasting, and also they go through the entire quality piece. We look through for risks, and it's a time that anybody can ask any question. So if anybody sees anything, if the workforce team sees something they don't know or agree, it's a time for us to level set.
And sorry, earlier I should have asked, you said you like to try to keep the differences, not this meeting, the other meeting, between at 5%.
The scores.
The scores,
Mhm.
the difference in the scores between 5%. Do you know how frequently that happens?
So we can provide that. We do keep track.
Good.
It's a little different for EA calls because those are pass fail.
Right.
So I'm just talking about the general form, but we do track
So for,
over time.
for EA calls, if you could we get the differential between scoring? I'm trying to phrase this right.
Yeah.
When the calls are scored differently in those meetings?
Yeah.
Can I do it for line 24? And you do it monthly?
Yeah, for the EA calibration sessions. Yeah, we do 2 per month right now, calibration sessions. So you generally only get through about 3 or 4 calls, but it's not the quantity. It's
Per
but we'll
session.
provide you with results.
Please.
Okay. That's late file exhibit 14.
Unless you have something. I believe we are all set. Thank you very much for
Thank
answering
you.
our questions.
Okay, we're gonna take a break in just 1 second, but for my understanding here, I'm gonna go through remaining reserve the rights. NECTA, Attorney Wright. Thank you, Attorney Wright. Attorney Nigro. Okay, thank you. When we return at 3:20, we'll do Commissioner Cross, followed by any redirect for this panel. Thank you. Okay, Attorney Vaughn.
Thank you, Chairman Gillette. During the break, I believe that Ms. Palella has been able to track down read-ins E, H, I, and J. If we want to read those in before you're across from the bench.
Very good.
Okay, so read-in E is that medical customers are allowed to have follow-up for legal collections. That was a question we got earlier today. We did confirm that. Read-in H, there was a question about what was in the LIDR approved and denial letters, and we did confirm. We have copies of letters if for some reason you want them submitted. But basically, they do include the details of the, if they were denied, it includes the details of what needs to be submitted in order to be approved. And then it also includes a second page that has all the assistance programs listed. And then similarly, the approval letters also include the details about the approval. If it's tier 1, it advises them how to enroll in tier 2. And then the second page lists all the other programs that are available, including the matching payment program. And then, let's see, read in I. There was a question about documentation of how the CSRs would review hardship documentation. And there is an SOP that was provided in Schedule H-2.10, starting on page 778. Okay. And then the last one is read in J, and the question was about the peak and off-peak related to LIDR, and it was in the final decision 17-12-03 RE11. And I can read the passage. It's on page 27, and it says, accordingly, the LIDR monthly usage cap of 1,200 kWh shall be designed to apply to on-peak hours first and off-peak hours second. And it has some additional language with examples.
Thank you.
Okay, thank you. So we're down to read in B, C, and D, correct?
That's correct.
Okay, thank you. All right, then we will conduct cross from the bench. I'll turn to Commissioner Conti first, please.
Thanks, Madam Chair. Thank you to the panel. With so much of this panel's discussion around AI between yesterday and today, and with all the work the company's doing with programs and contracts, is the company, I just want to make sure the company's engaging with the legislature in regards to Senate Bill 2 enact concerning artificial intelligence.
So as part of the AI steering committee working group that's been established, we have representation from audit, risk, legal, regulation within there to ensure that we adhere to federal, state requirements in regards to the management of our solutions and how we take those forward to protect our customers. So generally, to answer your question, yes, that anything that would be a regulation would be considered as part of that evaluation within the risk group.
Actively, I would say your team is actively tracking, working with the General Law Committee on this bill, just to make sure that the company is aware of the things that they're looking to adopt, and you're taking that into consideration for the programs you're implementing.
Yeah, so this is the specific regulation you would like me to check?
It's not necessarily specific regulation. It's just it's a Senate bill currently going through the legislative process right now in the legislature through the General Law Committee.
Okay, yeah, I mean, I'll check back with our legal and regulation colleagues.
Yeah, I'll just give John Vamos a ping. He can give you the answer I think I'm looking for.
Okay, perfect.
Thanks.
Thank you.
Commissioner Conti, would you like a read-in on that?
Yeah, I think a read-in would be sufficient. I don't think it levels up to a late file.
And that's just confirmation of the awareness that there's a pending Senate bill.
Yes, and that you're actively, following, tracking, and working with the legislature.
Okay, absolutely.
Yeah,
Thank you.
thanks.
Okay, thank you. That's read in K. Anything further? Okay, a couple questions. Circling back to read in A, which I think I missed the response to this morning, but in reviewing the broadcast, I'm not entirely sure that we got what we were driving toward. So let me just re-ask the question and then pose it probably as a late file exhibit. So specifically yesterday, I think when we were discussing this matter with Pure staff, I believe I heard the company's witness indicate that the LiDAR implementation costs shown in CAE 40 included consulting costs. And I also thought I heard the company's witness indicate that only LiDAR capital costs are included in the application. So if I heard both of those two things correctly, I'm wondering how the company makes a determination to capitalize the LiDAR consultant costs.
But if we just take 1 second to
Of
compare
course.
notes. Madam Chair, I think we're gonna have to take a late file, but just to make sure we don't swing and miss twice, could I try to say your question back to you to make sure I'm following what you're seeking?
Please.
So you heard from us that the LIDR capital cost include consulting costs. And you're seeking to understand how is it that the company determined it was appropriate to capitalize those consulting costs as an element of the overall cost of the LIDR project.
Exactly. Perhaps there's a protocol or internal document narrative. So if you could provide that as late file exhibit 15.
We were unable to find that answer sitting here, but we would be happy to answer that late file.
Thank you so much. And then I guess what I will note as late file exhibit 16 is to restate read in A. I think what we were seeking was to provide a breakdown of the total LiDAR implementation costs by year, whether they have been incurred or are projected, detailed by cost category. So again, I apologize, I missed the read in A answer this morning, but it's my understanding that we didn't quite get to the level of detail that the authority staff were seeking in the read in response. So if I can make that late file exhibit 16, please.
All right, just to talk further a little bit about what was twisting us around as we prepared that read in. I understand there's 2 categories of costs associated with LIDR. There may be more, but 2 for purposes of this. One that relates to the implementation of a 2-tier structure and another that relates to the implementation of a 5-tier structure. Is Pura seeking information regarding one of those or both, or? And we'd be happy to do whichever, of course.
I think that's helpful. I think we want what was included in the application in CAE 40 and UI CIP 5 line 154. So I think part of that was we were unclear whether those were tier 2 or 5 tier. So perhaps that level of granularity could be specified in the company's response. Perhaps it's a mixture, but it would be helpful to understand the delineation.
And I think I understand, and to just once again try to say this back to you, you're seeking an itemization of the cost and an indication as to whether they are actual or projected, and then some clarity as to whether those amounts relate to the 2-tier or 5-tier.
All of that was correct, and then detailed by cost category. So I think the examples that were provided by the company previously were software licenses, hardware, consulting costs. So
Is that sufficient cost category?
yes,
I understand.
thank you very much. So it's late file exhibit 16. Okay. Moving on, I just want to revisit the security breach conversation that we're having, I believe, with OCC earlier today. So I was listening to the exchange and heard the robust, heard the comment that the company has, I believe the terminology was robust expectations of your employees. I think what I missed during the exchange was whether those robust expectations were in place prior to the breach, or if those are somehow like new expectations or protocols that have been implemented.
So I don't, my understanding is we didn't have a breach. We had a security incident where somebody was succumbed to a phishing with the gas companies, not UI. And just in general, I think we talked about the fact that employees would not be sending reports to external parties.
Okay, so the incident, the expectations that you had of the employees, whether they were UI, CNG, SCG employees, I guess I was assuming that those expectations or protocols were consistent across.
Yes.
So were those expectations in place prior to the incident that occurred?
Absolutely.
Okay. Have they been reviewed for effectiveness since in light of the incident?
I mean, I defer to our corporate security team, but I understand that we definitely looked at all of the protocols. We right after that, believe there was a training session that was shared with the employees that has been shared previously, and encouraged people to remind themselves of the appropriate steps to take when they're reviewing emails and determining whether or not it might be a phishing incident.
Thank you. And if there's a later panel, I should direct this question to, I'm happy to do so. But the next question I have is, if within these expectations that you have for employees, are there specific remediation measures for an employee that is found to have caused or contributed to an incident or breach?
There would definitely be an investigation and an assessment of the issue at hand and what appropriate steps should be taken given the circumstances of the incident.
Thank you. Are you able to elaborate on what some of those might be? Like, is it additional training? Is it?
Yeah, I think training potential for any disciplinary action potentially if we felt that it warranted that. And just making sure that not only the employee involved, but all employees are made well aware of the potential for the situation, what the particular example might be, and then understanding that because every day you see new phishing incidents, new sort of strategies or tactics. They're improving every day from a phishing perspective. And so I think that the company is making sure that everybody's up to date on the latest potential scams there may be out there to be wary of.
And we do the same with our customers. So, working with our agency colleagues and specialists in cybersecurity, if we do find there's new methods of scam or phishing, then we update content on the website to reference those other scenarios to make our customers aware as well.
Thank you.
Yeah, and we've had a long history of that. Probably if you search old press releases, you'll see like there was the green dot scam at one point. There was, use of go buy a card and that's how you need to pay, things like that. So we just keep building on as Mr. Patterson said, we keep building on the examples and including them when we refresh everybody's documentation on how they should be handling these types of situations.
Okay, very good. And I think a moment ago, I made an assumption in the basis of my question. If I could just back up and make sure that that was accurate. So the assumption specifically was I was assuming that UI, CNG, SAG, that all those employees received the same training, and that all of those employees exercise the same like fishing protections. But if there's a delineation between UI versus CNG, SAG customers, if you could clarify, please.
No, it would be consistent across the companies.
Okay. Very good. And then just to clarify my understanding of the exchange earlier, I think there was an exchange regarding notification of customers if there had been a security incident and involving that customer's data. It was my impression from the exchange that from the company's testimony that there is no written procedure for how to inform customers about security incidents with respect to their information, but I wanted to make sure that that was an accurate understanding of the testimony.
So I know that we work with corporate security on if there is an incident, we work collectively with them and other stakeholders to determine what type of communication there might be. But my understanding is and that might be, we tied into our emergency preparedness team. I know that they were engaged in the last example, but I know there are some templates and set steps to be taken whenever there's a particular incident. We typically let the corporate security team take the lead there, and then the customer service team would support with any type of actions, outreach to customers, et cetera. So.
Okay, so there may be written
Yes.
procedures. May I then ask, as a late file exhibit, which I think we're up to 17, for the company to provide written procedures of how they inform a customer about a security incident with respect to that customer's data? Okay, thank you. Okay. Thank you. My final question, believe it was yesterday afternoon that there was a conversation about security deposits for non-residential customers. My understanding of the testimony was that the necessary internal system updates had not yet been made to enable the collection of security deposits for non-residential customers. If I heard that correctly, I think the part I didn't hear was if there was an estimate on the potential implementation timeframe for when that system change might be enabled.
We don't have a current estimated timeframe.
Okay. Prior to, I want to say yesterday's testimony was that the company was re-enabled or empowered to again begin collecting security deposits for non-residential customers, and I want to say it was the fall of 2023. Do you recall like the previous date that like essentially the date where that practice was put on pause?
I don't know the exact date. I mean, I know it was during the COVID pandemic period, but I don't recall the date.
Thank you. I couldn't either, but I don't think the specific date's necessary to my question. So pre-COVID, when the company was allowed to collect security deposits for non-residential customers, did the company have any expectations or analysis that indicated whether the collection of security deposits for non-residential customers had could be correlated to a reduction in uncollectibles for that customer class?
That's an excellent question. I wasn't with the group at that point, but that is one of the considerations as we look at implementing them to understand if we have any type of analysis or study to say, the cost benefit of using security deposits, and making sure that we feel that it is in the best interest and that we believe it's going to have a real impact on collections and arrears balances. But I don't have any firsthand experience with that research.
Thank you. Is it something that you believe the company possesses, as in if I issued a late file exhibit?
I don't know that the company has that. I myself would reach out to others, including perhaps if Eversource has some perhaps data that they would share with us. But I don't have firsthand knowledge that we have that analysis available.
I appreciate that. I think what I'd like to do is issue that as late file exhibit 18. If the answer is that the company does not have any responsive analysis, then that can be the response to the late file exhibit. But if I could pose it as late file exhibit 18 and ask for any existing analysis or data that the company has regarding the correlation of security deposits for non-residential customers and their impact on uncollectibles for that customer class, please. And that's it for me. So if the company needs a moment to consider redirect.
Commissioner Arconti, apologies, just to do the read-in key. I've confirmed with John Vamos that we're tracking the legislation in regards to the GNI. Thank you.
Thank you.
We just take a 2-minute break, a 5-minute break, sorry.
Sure. We will recess for 5 minutes.
Thank you.
Okay, thanks.
Attorney Vaughn?
Thank you, Chair Gillette. We just have a brief redirect
Okay.
for Mr. Patterson. Mr. Patterson, when you're ready.
Yes,
Earlier today, do you recall cross-examination from the Office of Consumer Counsel regarding customer satisfaction survey results?
I do.
And do you recall cross-examination from the Office of Consumer Counsel regarding the difference in customer survey results across various channels?
Yes, I do.
And could you provide any additional information that the company may have on customer service results?
Yeah, absolutely. So one of the additional customer service metrics that we track as an organization, which we provided in testimony on the prior rate case, as well as this one, is Net Promoter Score. So NPS, or Net Promoter Score, is a global benchmark metric for customer satisfaction used within the utilities industry here in the USA, and as well as other industries. And we implemented that probably 18 months ago in UI. And our performance has been tracking at a plus 31 score. And just for everyone's awareness, the measure of Net Promoter Score goes from minus 100, which is really, really bad, to plus 100, which is Disneyland, and everything in between. The utilities industry in the US just now is plus 16. So as a kind of standard average across the United States for energy utilities, it's plus 16. In UI, we're at plus 31. So that's an exceptional service for our industry here in the US. One of the other things I wanted to touch on was in regards to the interest in our customers who are on payment plan programs and hardship customers. And we have some really great feedback through our customer satisfaction surveys that I would like to read. And these are customer quotes. So anytime when I've been having struggles due to my health, you have been truly helpful about breaking my payments up so I can afford them. Thank you very much for your efforts. Your service is very reliable. Customer service has helped me repeatedly when having financial difficulty. The customer service reps have always been kind and respectful, and these go on. And it's not to say that we only look for compliments in our customer satisfaction, but we get many of them. And it's something just to put in context here that our UI customer service performance is exceptional for this industry. And the team here are unbelievably diligent and professional in everything we do. However, there's always room for improvement, and that's why we have Net Promoter Score, customer satisfaction surveys to look for those areas of opportunity for improvement. Thank you.
Thank you, Mr. Patterson. That's all we have for redirect.
Thank you. Then with our thanks to the panel, this panel is excused. And we will move to the company's compensation and benefits panel on page 8 of the agenda. think that would be appropriate. Okay, Attorney Vaughn, when your witnesses are settled, if you could introduce your panelists, and then I will administer the oath.
Absolutely, thank you. Would the panelists please state your full names and positions for the record? Beginning with Ms. Brown.
Lee Brown, Vice President of Sustainability.
Andrea Van Luling, Networks Controller here on behalf of UI. Jacqueline Rosado, Senior Director, People Business Partner.
Brian Williamson, Director of Benefits and Retirement Programs.
Paul Visconti, Vice President of Total Rewards and People and Organization Operations.
Thank you. Ms. Van Luling and Mr. Hurwitz, you remain sworn and previously adopted your testimonies and interrogatory responses.
Thank you. The only witness on the panel I didn't hear was Mr. O'Neill.
Yes, I believe that we did notify the case coordinator that Mr. O'Neill would not be appearing on the panel.
Very good, thank you. Okay, if the new witnesses could please raise their right hand, I'll administer the oath. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury. Thank you, Attorney Vaughn.
Thank you. Mr. Williamson and Ms. Fournier DeCoste, as part of your preparation for this docket, did you provide pre-filed direct testimony and exhibits which were marked as exhibits UI CBP 1 through 17?
Yes.
And Mr. Williamson, Ms. Fournier DeCoste, and Mr. Visconti, as part of your preparation for this docket, did you provide pre-filed rebuttal testimony which was marked as exhibit UI rebuttal 1?
Yes.
Yes.
Thank you. Ms. Williamson, or Mr. Williamson, Ms. Fournier DeCoste, and Mr. Visconti, did you also sponsor responses to interrogatories submitted in this proceeding?
Yes.
Yes.
Do you have any updates or corrections to your pre-filed testimonies or interrogatory responses not previously identified for the record in an interrogatory response?
No.
No.
Yes.
Yes, you do. Okay, thank you. Could you explain that update?
Yes.
Ms. Van Luling and Ms. DeCoste.
Subsequent to the submission of RRU 128, which we stated within, please note that the collective bargaining for Union 470-1 is currently in negotiations. The company will update its proposed revenue requirement to reflect the results of those negotiations if they conclude prior to the close of the evidentiary record in this case. The negotiations need to conclude May 15, 2025. As part of the negotiations, the following changes will be reflected in the revenue requirement. Effective May 2025, there will be a general wage increase of 3%. Effective November 2025, there will be a general wage increase of 1.5%. Effective May 2026, there will be a 4% general wage increase, along with the ratification bonus amortized over the effective period of the agreement. Effective November 2025, premium pay will be increased 50 cents for the rubber gloving. Premium pay will be increased 50 cents for rotating shifts, and the training premium will be $6 or a flat rate of 10%. The boot allowance will be increased $70, and there are some moves in the user categories that will impact allowances. Effective January 2026, all union employees will receive a 401k match of 150% on 7%. Effective May 2025, certain customer care positions will have base hourly increases to $32 or $35.50 an hour. And in addition, we have eliminated the 0.5% incentive target.
Thank you, Ms. Van Looling. And Ms. Fournier DeCoste, Mr. Williamson, and Mr. Visconti, subject to that update, do you adopt your pre-filed testimonies and interrogatory responses as part of your sworn testimony in this proceeding?
Yes.
Yes.
Thank you. Ms. Rosato and Ms. Brown, did each of you also sponsor responses to interrogatories submitted in this proceeding?
Yes.
Yes.
And do you have any updates or corrections to your interrogatory responses not previously identified for the record in an interrogatory response?
No.
No.
And do you adopt your interrogatory responses as part of your sworn testimony in this proceeding?
Yes.
Yes.
Lastly, Ms. Rosato, for the purposes of admission into the record, have you reviewed and do you adopt interrogatory responses sponsored by Khadijah New Johnson and Juliana Molasani?
I do, yes.
Thank you. The panel is available for cross-examination.
Thank you. We'll begin cross-examination with authority staff, please.
Thank you, Chair. Good afternoon, panel. My name is Karima McDonald. My questions will be targeted to the ESG interrogs that were sent to the company. I'd like to make reference to UPA 16 and UPA 26. All right, thank you. Ms. Brown, thank you for explaining how UI supports the broader ESG goals set at the corporate level. Can you walk me through how the company ensure those high-level goals translate into meaningful outcomes here in the state, especially in communities where vulnerable to energy or climate challenges?
Yes, thank you. So in regards to just overall, I would say, and as we've noted in other responses, there's a strong correlation between our commitments, Avangrid's commitments from a carbon neutrality perspective and the state policies. So there's strong alignment there. More specifically, I can speak to the actions in regards to the alignment on lower emissions, aligned with our carbon neutrality goal, and programs that the company has, for example, energy efficiency, the solar programs, et cetera. So I would say in general, there's very strong alignment, and I think that was outlined, as you noted in the proceeding. I would also note in an additional filing in regards to the considerations for our just transition framework that we've included in our 2023 sustainability report, and the pillars and the principles that are outlined there, how that strongly supports again, I think the policies and commitments that the actions that the company takes, as outlined in a number of the responses for community engagement on energy efficiency programs, commitments in regards to the solar programs that also are aligned with the equity strategy. So I think I am not an expert on the company's UI's actions and programs, so that those responses have been provided by other experts. But I believe that we have referenced that strong connection again, as we think about the just transition programs and the Avangrid's emission reduction strategies.
Just by title here, but do you know who in UI is responsible to making sure that those local efforts do align with the broader ESG goals?
From the IR responses, Eric Roby is one responsible for a lot of the energy efficiency programs. I believe Bob Whalen is another resource that was also, we witnessed those IRs.
What are their titles? Do you know?
I don't know off the top of my head.
Okay, all right. Thank you.
Yep.
And so for how the goals are set at the corporate level, how they show up in the local decision making, are there internal checkpoints within working groups or other processes that help keep these goals in focus?
So overall, from a Avangrid sustainability goal perspective, we have a steering committee, and we have goal owners. That steering committee meets on a quarterly basis. We have representation on that committee from the different parts of the business, whether it would be network participation, or power representation, or other parts of the company. So it includes senior leaders representing all parts of the organization. And each of those goals have a senior leader goal owner that also sits and supports across the businesses. So by that representation and participation in that committee, there is a strong connection with the business in general, as there is representation from all parts of the business. We then work with the goal owners who are coordinating, for example, if we think about at an applied local level, thinking about fleet or facilities as an example, or actions taken around assessing network emissions losses as another example. So that's information that is then collected and coordinated at UI and across the businesses, where we then can leverage that information to then determine, are we on track with our goals? What actions are being taken? We, in the sustainability organization, we work across the business to collect information and understand what actions and programs are being taken to support our initiatives.
All right, thank you, Ms. Brown. I'd like to move on to UPA 40 and 41. And here, it's helpful to know that the ESG goals are owned by senior leaders and then reported to the CEO and the audit committee. And you touched on this in your response just now, but is there internal protocols that list how these goals are then implemented at the utility level?
There is no explicit governance or structure that speaks to how it's implemented at utility level.
And so there are no oversight mechanisms to ensure that the objectives are effectively implemented and monitored at UI?
No, there's no structure in that sense. It really, the goals themselves are really considered across the organizations and partly built on assumptions, for example, like state policies, where we have expectations around renewable targets, but it's not explicitly articulated and driven down at a utility level.
Are there any talks or conversations underway to ensure that happens?
We have not really had such an explicit articulation, partly because some of the outcomes are unknown. So again, we think holistically about those commitments. We have the different elements that contribute to, for example, emissions reduction. Fleet would be an example, but we don't have guaranteed outcomes of one, if it's possible to get recovery of those vehicles, as an example, if we do look for electric vehicles, nor do we necessarily have full control over if those vehicles, as an example, are even available. So it is at a high level corporate goal, and we coordinate, but don't have any direct commitments at an operating company level.
All right, thank you, Ms. Brown. UPA 21 and 30 gets a bit into the measuring and tracking of performance. And I heard your comments just now, but for the coordination piece of it, are those results shared internally? And if so, how frequently?
Yes, and unfortunately, I'm slow in downloading.
Take your time.
Yeah. Can you say those two numbers again, please?
UPA 21 and 30.
Sorry. What? You have it? Okay. Yeah, okay, thank you. So, I can speak to the goals and how they align, and then Catherine can speak to from an incentive perspective. So as we noted, we do have strong governance and structures around the sustainability goals. Part of that is a strong alignment with our incentives, company incentives. Some of the key areas that would be considered in those incentives would include things like safety, our TRIR rate, as well as our supply chain, as another where there is strong commitment. I don't know if you want to speak to that.
Yes, so our incentive program at a AGR overall networks and also networks, and then it can be seen individually in executives, has a component of sustainability within it. As Lainey Brown just spoke to, we have health and safety measures. We have projects, sustainability projects, and we have customer service metrics and governance metrics within various EVP objectives.
Thank you for that. The results of all the efforts that was just mentioned, how are employees aware of what's happening and the role they're playing? And how often is that information shared with them?
Yeah, so I think speaking to, I think, multiple elements. One is we, as a sustainability team, we work, we present to and speak to our employees across the organization. In some cases, for example, we'll participate and present information on the goals or on sustainability in general at CEO town halls. We do that at an avant-garde level. We've also engaged broadly across employee groups, et cetera, organizational groups in general. From a sustainability goal perspective and outcomes, we do provide that information in our sustainability report, and we encourage encourage our employees to review that report to be able to understand the our outcomes for the year. So there's no formal structure per se in that we speak to every employee on a quarterly basis, but we are very actively engaging with our employees and educating them in general on sustainability and more specifically on the actions we're taking, particularly because we like to make sure that people understand how their roles align with the work we're doing and the commitments we have.
And if I heard you correctly, the results are of their performance. They don't usually see this until the sustainability report.
I'm speaking more specifically to the goal results.
The goal results, okay.
Yeah.
What about the role that they're playing internally to make sure that they meet those goals? Is that somehow tracked? Is it shown up in scorecards or in their individual performance reviews?
Yeah, so for this, specifically for the goal owners, we review that on a quarterly basis, individually with those goal owners at the steering committee level, and then presented also to the management committee and also to our audit committee. So quarterly, we absolutely work with the employees who own the goals and on a quarterly basis.
All right, thank you. Let's move on to UPA 23, which ties into your response just now. I'd like to hear how non-executive and union employees hear that information as to how the goal owners are doing and are the specific unit that's responsible for achieving those goals.
So if we look more broadly, I'll give an example that's probably the most obvious, and I would also defer to my colleagues responsible for health and safety. But there are ongoing reporting, for example, on our health and safety metrics, particularly around our safety numbers, reporting, et cetera. I couldn't give you the frequency, but I think it's more than quarterly. So that I would defer to those. So that there's clear understanding of the safety actions, their goals and reporting. And again, I would defer to those. I would also say, as we look at things, now they're not our goals, but I think more broadly represented, customer excellence or Katie and safety information, again, very much, I would say the employees, particularly who are focused in those areas, are very much aware of those and understand that more frequently. Those are not necessarily part of our reporting, say on a frequency basis, but those would be ones that I think would be represented and clear to employees. We also have a supplier sustainability monthly report that goes out for folks who are participating in that program, who are key procurement, other employees, or supporting those efforts. And so that is also one where we have more frequent updates. So depending on the goal, I would say, depends on the frequency. And I think the breadth of the application of those goals, for example, safety, there's a whole lot more awareness and information that's shared more broadly.
All right, thank you, Ms. Brown. Is the company considering ways to offer ESG-related incentives to employees beyond senior leadership?
I would defer to my HR colleagues.
Hi, thank you. On the APA level, so for those who aren't executives, their incentive award is broken into 3 components. 35% is Avangrid overall, 35% is their business or their functional area, and then 30% is their own performance. For the Avangrid and their business functional area, the ESG goals, a component of them flow down to their incentive award. So they're directly impacted financially on how those results happen. And then individually in their own goals, which are broken out per their department area or specific to their department area, they are also awarded through their individual performance.
Okay, thank you. And how often would these employees receive recognition for their efforts?
For incentives versus operationally, I'd have to defer to the business area to see how often their employees are aware of, for example, KPIs. I know in customer service that they are very aware of the metrics that they have and they're monitored regularly. For the actual incentive payment, that only comes once a year based on their individual performance and approved metric attainment for the incentives.
All right, thank you. Let's move on to RRU 389. Here, the company response shows their ESG-related credit ratings from Moody's, Fitch, and S&P. Can you walk me through how these ratings actually tie to the day-to-day utility operations?
Yeah, so I'll just speak first broadly about ESG scores and the methodology, and then I can speak in more detail.
Thank you.
As noted in the IR, there are many ESG scores, and all of the methodologies can be different. Oftentimes are different. So for example, the 3 that were provided, each of those agencies have a different methodology. And so it's hard to be specific because it's so broad. And the methodologies are very much unique to each organization. Some of the examples that we provided, in terms of the E, S, and G, and the categories that could be included are things like, in many cases, looking at climate risk and impacts. But it could also be emissions. It could be waste or water as areas of focus in those areas. From a social perspective, it could be employees, communities, suppliers as elements of the assessment and that position. And then governance is very much based on tends to be more consistent, and that's really in regards to policies and structure. So it is very broad. In regards to, for example, Moody's, their environmental commitment or their environmental score is very much based on assessment of climate risk. How much does this company have exposure to climate risk based on their risk models? Moody's also looks at and considers key elements in their S score in regards to affordability. So customer affordability does impact the score as well as the regulatory environment. So those are elements in Moody's specifically, but each one again has a very different assessment for those scores.
And even with the differing methodologies, do these scores influence the internal decisions at all?
So I think it goes to the core elements of our sustainability, sort of the structure of sustainability in general. And that some of the elements of sustainability are ensuring that we are providing information that different stakeholders can use to make decisions. So some of this information speaks to what information we provide in our sustainability report, as an example. That is one element. Obviously, where we look at and determine where there's opportunity to have impact or improve our ESG scores, we would support that. In general, and again, this is very much dependent upon the different credit agencies. They have more or less impact on the overall credit score. So that also just is a determiner of what actions we would take to try to change it and how much does the ESG score actually change the credit rating itself.
Okay,
So
so it does have some influence.
it does have some influence on what we disclose, I would say, or how we think about information provided that could support an improved score.
If we were to, still on those scores, if we were to compare UI, or perhaps I should say Avangrid, against, peers, other utilities, how well is Avangrid doing?
I hate to continue to be a generalist. I'd like to maybe come back with an answer on that to provide you a better comparison. I think in what I've seen in general, when we look at, for example, Northeast utilities with Moody's as one example, the climate ratings are very general. So they would look at all Northeast utilities in a very similar climate risk perspective. They wouldn't necessarily say, you're in Connecticut or you're in New Hampshire, I see a different climate risk. So in some cases, those assessments are more general. I would defer on looking at peers relative to to social as an example.
Okay. Thank you. Let's move on. You don't need to provide a follow-up for that. Let's move on to the DEI questions that were submitted, UPA 35 and UPA 38.
I have 38 in front of me.
Okay. How does the company evaluate whether its DEI strategies are resonating across the different units, including at UI?
I don't know.
Like, are there structured employee feedback processes for DEI reviews? What internal metrics or mechanisms are used to evaluate the success of these programs or initiatives?
So we do have, a dashboard that we leverage that provides us with all of our metrics for, our diverse data for our employee workforce that we leverage when we're when we're talking through our workforce and what strategies we're going to put in place.
And are employees' reviews taken into consideration, making any policies or adjustments to initiatives or programs offered at the company?
Employee reviews as in, can you clarify?
Any reviews on DEI initiatives or programs that are being offered at UI?
Yes, as a people and organization, we do look at the data and do review what programs in place, if we're going to be implementing training programs or focusing or targeting on specific data that we receive from those dashboards too. So there are reviews that are happening internally to make changes.
And how often are these dashboards reviewed and changes made?
Our dashboards are updated on a monthly basis with all of our data, and the reviews happen when we, meet as a P&O organization to talk through our workforce strategy plans.
All right, thank you.
You're welcome.
So Avangrid has a 2025 goal to increase women in senior leadership. What role is UI helping to meet that goal?
The leadership is defined as directors and above. So any females at UI would contribute to that goal.
So are there leadership development programs in place? How would a female in the organization achieve that success of being part of senior leadership?
So we have succession planning in place where we talk to our female top talent that are looking, to talk through their career plans. There are development programs in place for different levels for our female talent to get them into those, leadership roles at the top of the company.
And how does the company measure the effectiveness of these efforts?
We regularly review our succession planning documents and talk through with our top talent to ensure that we're aligning and that that they're progressing throughout the organization, ensuring that we're, talking through their performance, personal development, and tracking those metrics as well.
And keeping the 2025 goal in mind. So how often is your regular review? Is it done on a monthly, quarterly, or annual basis?
Let me confirm. Typically we have been reviewing that data on a monthly basis with our dashboards.
Okay. And these development pipelines, did they start as a result of the 2025 Avangrid goal, or this was something already in place?
This is something historically that we have been doing all along.
All right, thank you.
You're welcome.
I'd like a late file to follow up or supplement UPA 35. I'd like the count of each demographic represented in tabs 1 and 2 of your confidential response to UPA 35.
Okay, I have that as late file exhibit 19.
So I'm looking at UPA 035 attachment 1. There's 2 tabs. Which specific information would you like though clarified?
Each demographic in each of the tabs. So I want the ethnicity and race and gender. I
Okay.
want the actual counts.
Okay.
Thank you. All right, let's move on to the community engagement and environmental justice. UPA 18 touched on this.
This is covered by Eric Roby and Al Carbone. I can speak to the higher level just transition element, but the specific community information, I may not have that specific.
Well, earlier you touched on some of how the broader ESG goals are, worked with the communities, but I would like to know if there are specific metrics in place to track whether these communities are equitably benefiting from the programs at Avangrid.
Yeah, so again, as I had mentioned, we have included in our 2023 sustainability report and continue to engage with the different business areas on our just transition strategy that looks at customers, community, suppliers, and employees. In that work, we engage with and support the businesses in the framing of the principles and the actions. And in many cases, we work with them as they report on or provide us more information about those goals and metrics. That being said, we work with them, they provide us the information. So in terms of the details at a community level, we don't have that per se. That I would defer to Al and Eric on the detailed actions, engagements, et cetera.
Okay. Do you know of any examples where community input shifted programs related to ESGs?
For the ESG goals, as an example. I have a better understanding, honestly, in work that's being done in New York than I do in Connecticut, so I would defer to my Connecticut colleagues.
Who are not here, to be sure.
They will be.
Yeah, just to
Yeah,
be
just
clear.
to clarify, Eric Roby will be here for the rates panel and Al Carbone will be here for the revenue requirements panel.
And I'm sure we can field these questions to the witnesses who sponsored the discovery requests.
Okay, sure. So I'll reserve the rest of my questions then for that panel. Let's move into procurement and local development, economic development. And reference here to UPA 37.
Sorry, what was the reference, please?
UPA 37. This is on supplier diversity.
Yeah.
Okay, so it's helpful to see that UI is reporting supplier diversity data at the operating level. Are there efforts on the way to grow relationships with the diverse community-based businesses, particularly for those who have low numbers reporting in that response?
So just in terms of overall how the program works, and again, I would defer to Peter Lavula, who will be, I think, on a separate panel.
He'll be on the revenue requirements panel, just to be clear.
Revenue requirement. Thank you.
So the procurement team who supports this initiative is actively engaging with different associations and organizations to engage with, build their knowledge of different suppliers across the different categories where they work. So I know that that is a key part of what our diverse supplier group, our equal opportunity supplier program and group is working towards. Specifically, I cannot speak specifically to the activity in Connecticut in terms of that engagement, but in general, there is a strong coordination with those associations and outreach and education, including attending conferences and local participation. So I think in general, that's built into the work that they do around building, understanding, and engaging at a community level and at an association level with the diverse suppliers.
All right, thank you, Ms. Brown. And for the community engagement part, can you refresh my memory just now, please? I didn't make a note. The panel I should speak to is revenue requirements also?
Yes, Mr. Carbone is identified as a discovery witness on the revenue requirements panel.
All right, thank you.
Eric,
Mr. Roby is identified as a witness on the rates panel, but we'll discuss that with him.
Okay. Thank you, Attorney Yvonne. I have one question though, and if it needs to be reserved for the other panels, just let me know. For the Community Partnership Initiative Program that UI participates in, can you clarify if this is supported by ratepayer or shareholder funds?
I do not have that information.
Okay, thank you.
Yep.
All right, let's move into energy efficiency and the climate commitments. UPA 29 talked about this for a bit. Is that something I can?
Yeah.
Okay.
Yeah, I don't think I was a witness on that one, so I was just.
I'm sorry, I don't know who I don't have the.
So the discovery sponsor was Mr. Armando Pereira, who is also a witness on a different panel. But perhaps we could see if Ms. Brown can address the question.
Yep.
All right.
I'll try.
I'll put you on the spot.
Okay,
All
it's
right.
okay.
I just would like to know where the process stands for the investment grade audit at the Avangrid properties. And specifically, are they facilities that are leased or owned by Avangrid, or is it both?
I will have to defer.
All right,
apologize.
I tried.
I tried to.
Okay.
Yeah.
Employee training. Did you sponsor those responses? UPA 42.
Yes, I'm one of the respondents. Yep.
Okay. Which will be let me double check. I think that's my final question. But I just needed to understand that exhibit. There are some trainings that have inactive next to their names. Can you explain that, please?
Can you in UPA 042?
42.
Can you clarify which attachment number and then which tab you're looking at or page you're looking at?
I'm going to do this from memory, and unless I can pull it up real fast. It was the tab that showed attachment 1 with the tab that showed all the list of trainings and their frequency in your 2025.
Do you know the word? I can search it.
Inactive.
Inactive.
It's in the mandatory course description tab.
Yeah.
There are some titles, specifically, here's one, 2024 workplace and sexual harassment. It has inactive next to it.
So typically inactive is when an employee is out on leave and is not an active, so they're showing up in a training report and they might not be active, working. So they might be on some sort of extended leave or.
I'm confused because I thought I am looking at the titles of the training, not employee information.
Apologies, it means the course is inactive.
Versus, and which means it was offered, no longer is being offered?
Correct. It could mean that a new version of the course is being like a 2025 version or updated version of the course.
Okay. All right, thank you. I think these are all the questions I have for this panel. Okay.
Hello to the panel. Janelle McGregory, staff attorney for the authority. I have one follow-up going back to UPA 36 on women in leadership. I know you all spoke a little bit to conversations and check-ins with employees to make sure that the pathways to senior leadership for women are effective. I want to clarify if there's any measurable data or quantifiable metrics that you're using to test the effectiveness of those pathways? Or are they mostly in informal ways, conversations, check-ins?
Yes, correct. Informal conversations, check-ins.
Okay, thank you.
Hi, good afternoon. Jim Riley with Authority staff. So we're going to begin with interim period FTEs. So the company included 69 FTEs for the interim period in its application, correct? I see Mr. Hurwitz. The company is including 69 interim period FTEs in its application, correct?
That is what's reflected in our initially filed revenue requirement as shown on Schedule WPC 3.15, as I think we described in the direct testimony of the revenue requirements panel. And at least one other place, we intend to update this for the most recent information available at the close of the evidentiary record.
Okay, so yes. So I think we're going to start that with the LFE request. So in the same format as RU 125 attachment 1, what the authority is looking for is a breakdown of the 69 interim period FTEs identified in the company's application. And please identify the position, indicate whether that position has been filled, is vacant, and whether the position was essentially incremental, like after the test year. In other words, was it a position created after the test year or not, or was it a position that existed prior to the test year? And whether the position is a union or non-union position. And if I believe there's a number of salary and benefits information in RU 125. If you could just keep that with the late file as well, that would be great.
Do you mind if I take one moment? We've provided something that sounds similar to what you're asking, and then I think I'm going to have some follow-up questions. If
Sure.
that's okay, but let me just. I'm struggling to pull up the data request that I'm recalling, and I don't want to use my second bogey on this question from Attorney Wheel. But I'm sorry to ask you to go through this question a third time, but I just want to make sure I understand exactly what you're seeking. So you're hoping to receive an itemization of the 69 incremental FTEs reflected in the revenue requirement between incremental to the test year? Actually, let me take notes and I'll go through my questions one by one.
Sure. Yeah, I think what the authority is seeking is just an identifier in a column. Was an incremental position since the rate year? So in other words, was it a newly created position since the rate year, or during that interim period was the position that essentially trying to fill a vacancy for a position that existed during the rate year?
So I think that question is just a little bit confusing to me. So the way the revenue requirement was developed, we began with the test year complement as of the end of the historical test year, like actual people in the building receiving a paycheck on that day.
Yeah.
And then we added to that the changes in headcount after the end of the historical test year in our initial filing that was through July for both changes in UI's actual headcount, like the number of people in the building receiving a paycheck, and open positions in active recruitment. So we can, no question, provide a breakdown of that. And I'm recalling a data request where we've done that, but struggling to pull it up on the fly. But then you said rate year, and that makes me think you're seeking some information relative to 220808. And based on what I just said, I think all 69 positions would count as incremental. So I worry I'm not.
Yeah,
down.
Yeah, I think my terminology is confusing there.
Yeah,
I'll-
so it would be the 69 positions in the interim period, as Attorney Riley referenced in the format of RRU 125 with the information provided there. And if you could also provide the 5 positions that are sought for the rate year within that.
Okay, just in the format of RRU 125?
Correct.
That I'm sure can be done.
Yes. I know, I realize you've, in RU 125, you've listed 40 employees that you've already hired. If you can add on to that, if you've hired 50 to this point, 45, that'd be in the hired category, and you have a vacant category and the rate year incremental category.
So just to say back to what, and I'm sorry to belabor this, I don't mean to be like this. You're seeking 2 things. One is an expansion of, or a document that is in the form of RE 125 UI attachment 1 that shows the 69 plus the 5. And then second, an alternative version of that same information that's more current. Or did I?
Yes. Yes.
Gotcha.
Whatever it would line up with your late file exhibit 1 that you're gonna file.
I understand. And thank you for bearing with me.
No problem. Thank you, Mr. Hurwitz.
To confirm, that's late file exhibit 20.
Thank you. Okay, thank you, Chairman. And next, we'll turn to OCC 50 attachment 1. And just to clarify, it's the original, not the supplements that were filed subsequently. And I just want to, once it's up for folks, just let me know.
Just pulling it up. Oh, sure.
Okay, thank you. So I just want to walk through this spreadsheet and make sure we're understanding the calculations here. So column A1 represents allowed distribution FTEs. Is that correct? For the historical data. Okay. And then B represents the total company headcount, and that's both distribution and transmission, correct? Okay, thank you. So if the if the authority wanted to derive the actual distribution headcount, it would need to apply the applicable distribution allocation factor in those respective rate cases. So subject to check 93% for 160604 and 82.28% for 220808. Is that your understanding?
You would need to, quote, distribution adjust these UI total actual headcount figures. My recollection is there is another data request response where we've done that using data through, I want to say calendar year 2024. I hate to make you sit here while I go look that up, but we could take that as a read in and I could dig that up for you tomorrow morning if that would be helpful.
Okay, so because I think we were headed towards a late file with another column for this with that calculation made through the historic, through present, just so the authority has that actual distribution headcount. So I guess for now that we could leave that pending as a read-in if
I'm like 85% sure we provided that in a data request response towards the end of the proceeding. It would have only gone through 2024. So if you're looking into 2025, I think we would need to provide you some new information.
Okay. So we'll just confirm via read-in tomorrow morning. Okay, that's fine with me. That's okay with you, Chair.
That's read in L.
Just to confirm, Mr. Horowitz, that would show the distribution employees that were in rates compared to what the company actually had in actual distribution employees. Is that what the
document I'm recalling, I don't recall it having both. So you would have OCC 50 on one and this document I'm recalling on another, but I mean, we can prepare a new document that combines them. That's no problem.
Okay.
That would be helpful.
So would you like to do the late file exhibit or?
If that's what you're seeking, yeah, we'll
That's
just
what
turn it
we're
into a late file now.
Okay. So Chair Gillette, just to clarify for the record, so the late file is going to be an additional column for OCC attachment 1. And basically the company is going to provide the actual distribution headcount for those historical data provided. So it's just going to be an extra column for allowed distribution employees.
And it was OCC attachment 1. What was the interactory?
It was 50 attachment 1.
OCC 50.
50.
Okay, thank you. And Mr. Hurwitz, I think we couldn't quite hear you. I think you might have, it's on right now.
My apologies. And I was with you, Attorney Riley, right up until the very end. You said an additional column for allowed distribution headcount, or I was anticipating actual distribution headcount.
Actual, yes, thank you.
That
mistake. Thank you.
I'm good. I understand.
Okay.
Okay, so we're going to strike read in L in favor of the late file exhibit 21.
Correct, Chairman. Thank you. Okay. So we're past some late files. Escalate. So I'm going to move next to the escalation factors. So does the company's 1.5% promotion rate account for position backfill? And by backfill, I mean, in other words, for every employee promoted, is there like a replacement employee that may be compensated less than the previous position holder?
So your question does the 1.5% promotion rate account for backfills? I think presupposes a number of things about that backfill. That backfill could have a wide variety of skill sets. They could be more or less qualified than the prior employee and could demand compensation that differs from that prior employee. Broadly, my understanding is the 1.5% promotion budget is a internal target that is broadly applicable. But I am not aware of it being so specific as, well, this backfill got this, as the person they were backfilling got Y, and so we have to make sure it's Z dollars to hit the 1.5%. I'm not aware of it being that specific.
Okay, so is there any sort of like averaging or in that calculation, or do you look at like your total dynamic and try to come up with a calculation?
The 1.5% is a generic budgetary estimate on promotions. We don't track them all individually or report on how many we've done per year per se. All the promotions are based on individual employee actions and can range. They can be promoted from one level to another level. It can be a backfill. And their salary is commensurate with their experience, reporting relationships within the department they're hired into, and internal equity. So it can range.
Okay, so I'm not quite, so the answer is no, it's not like a calculation that I'm still a little lost about how you end up with the 1.5.
The 1.5 has been the historical bucket for promotions. And so they've used that in theory each year for promotions. And so the 1.5 was derived off of the historical budgeted used in actual amount. And so when you're looking at promotions, there's going to be different levels and different pay ranges walking into those promotions. So someone might in theory be deserving of 1.48 because they had a slightly higher income and they had been at their job for a little bit longer. Someone may be more deserving of a 1.56 because they're higher performing. It's different roles and responsibilities. And so that's why that 1.5 is used to manage, like depending on what the skill set is, what the needs are for those promotions.
Okay, understood. Thank you. So I'll move next to overtime and premium payroll. What relationship has the company observed between its vacancy rate and overtime utilization? So as vacancies increased, does overtime proportionally increase to cover essential functions?
So when you look at overtime, you need to look at like what that overtime is actually being used for. And so a lot of uses for overtime would be things like trouble or storm or capital work. And trouble or storm work isn't going to necessarily be dependent on vacancies, right? Like that has to happen when it has to happen, and it's not controllable. And so there isn't a direct correlation just because of the different types of buckets and the different reasons that you'll see for overtime work.
And so I think one of my next questions might help this discussion, which is, so how much of the companies, if you had to, I guess on a percentage basis, what would be planned versus unplanned overtime for the companies overtime?
We have that. I just don't have that at my fingertips. So I could do that as a percentage read-in for 2024 tomorrow, if that works for you.
That works for me.
I'm sorry, I missed that. So you want to read in M is,
Yes, so it's going to be a read-in on the percentages of the company's planned versus unplanned overtime.
okay, thank you. Is that a good place to stop?
Yes, it is, Chairman.
Is Chair Gillette, just to start to interrupt, was read in L converted to a late file?
No.
And are you skipping over it?
Yeah.
Okay.
Sorry, just thank you to be clear. So that's read in M. Okay, so we are gonna stop there and reconvene tomorrow. I'm sorry, and the time period on read M, just to be clear, is 2024. Is that what we're looking for?
Yes, Chairman, that's.
Okay. Okay, very good. So I have 4 outstanding read-ins, B, C, D, and now M. All of their read-ins have been addressed. And I have late files registered through 21. So we will adjourn and reconvene tomorrow at 10 a.m. Continuing with this panel and Authority Cross. I do expect that, and I don't want to put Attorney Wheel on the spot about his 2.5-hour projection. I do expect that we're not taking the full 3.5 hours. So Attorney Wheel, we may get to you before lunch tomorrow. In which case, I don't expect that the company's panel for electric operations, I wouldn't expect to get to them before lunch, but I would expect to get to them after lunch. Okay. All right. With that, we are adjourned. Thank you.